President Administrator, if you want, you can start now. Thank you very much to everyone.
Thank you. Very good. All right. Welcome, welcome. This is the battle for third place. I'm sure you're all very excited to start today and be done with today. But we still have a little bit more to go. Before we begin formally, I'd like to ask my co-arbitrators, Orlando and Sui, to introduce themselves and to give them a little bit of their background, which will be helpful for how you manage your presentations. Let's begin with Sui.
Hello, everybody. My name is Sui, and I'm dialing in from Kuala Lumpur, Malaysia. I'm based here at times, and other times I'm based in the USA. I am a construction lawyer by background, and for the last number of years, I only sit as arbitrator and adjudicator. I've been very involved with this Pre-Moot, particularly here in Malaysia, and I'll be judging the Malaysian final in a few weeks in Malaysia. And I was a guest lecturer in Mexico City last year at the university. And so I welcome you all to this moot and congratulate you for getting this far. Thank you, Marcio.
Thank you, Sui. Orlando?
Hi, hello, everyone. My name is Orlando. I'm a senior associate at Hogan Lopez in Mexico City office. My practice, I would say, it's a mix of investment arbitration, commercial arbitration, and I'm very pleased to be with all of you and looking forward to have fun in this final round.
Thank you, Orlando. My name is Marcio. If you have any difficulty saying my name, you can call me whatever you want. I really don't care. I am originally from Brazil, where I obtained my first degree in law. So I'm a civil law trained attorney. I obtained my first master's degree also in Brazil. Then subsequently, I obtained an LLM in California in the University of Pepperdine. It was an LLM in International Commercial Arbitration. I am an associate with the team of King and Spalding in New York City. My practice is divided about half and half between investor state and commercial arbitration. And I am a veteran of the VisMoot. I was a Moody for 2 years, 2 editions of the Moot in 2008 and in 2009. And then I was a coach for almost 8 years. So I've fairly experienced in the VisMoot, very happy to be back. And I wish you all the best of luck. As we begin, the first question that I have for the teams is, have you agreed on a sequence of presentations and time allocation? I will begin with the claimant on this question.
Mr. President, good afternoon from Mexico City. Unfortunately, the parties have not had the chance to address this issue, but if there is no problem, we would like to propose that respondent can go first on the question of jurisdictional issues, and the claimant can address the merits first.
And what is your proposed time allocation, counsel?
In this sense, we propose that each oralist will have 14 minutes for their own speeches, reserving 1 minute for rebuttal and sub-rebuttal.
Very good. Thank you. To the members of the team of the respondent, is that agreeable to you or do you disagree?
Yes, that is agreeable for us.
I'm sorry, Yusuf, you are sideways.
Oh, I'm sorry.
Okay. I did not mean that you were sideways in any other fashion other than logistical. What is the proposed time allocation for the respondent team?
It is also 14 minutes and 1 minute for rebuttals and possible series.
Wonderful. Thank you. Is that agreeable to the members of the tribunal? Sui, Orlando?
Yes, Mr. Chairman.
Okay, wonderful. Yes, I also agree with that. Yusuf, do you need a minute to prong your camera?
Yes, I'm really sorry, Mr. President.
That's absolutely okay. Technical issues occur.
Thank you for your time.
That's quite all right. This is when duct tape comes in handy. Are you prepared to commence?
I'm sorry, Mr. Arbitrator.
Can you hear me?
Yes, I can.
Wonderful. If I could trouble you to lower your camera ever so slightly, we can only see the top half of your face. Perfect. All right. Very good. Now that we have that squared away, are you ready to commence?
Yes, I am.
Well, then please, you have the floor.
Thank you. Greetings, members of the tribunal. I'm Yusuf Hindi, representing respondent Equatoriana Geoscience Limited, and I'll be pleading alongside my co-counsel Mariam Rabia for 14 minutes each, leaving 1 minute for rebuttals and possible serial rebuttals. I'll be addressing the matters relating to the procedural issues of the case, and she'll be addressing the matters relating to the substantive issues of the case. My pleading will be divided into two main submissions. Firstly, that the arbitral tribunal has no jurisdiction to hear the dispute at hand, and secondly, that the arbitral proceedings should be stayed or alternatively bifurcated. Firstly, the arbitral tribunal has no jurisdiction to hear the dispute, as respondent had no capacity to conclude the arbitration agreement. I'm really sorry.
Yusuf, if you need a minute, please take it.
Thank you. Can I commence?
Please.
Thank you. So, firstly, the arbitral tribunal has no jurisdiction to hear the dispute, as respondent had no capacity to conclude the arbitration agreement, providing such jurisdiction to the tribunal. And accordingly, to assess whether respondent had the capacity to conclude the arbitration agreement at hand, the law applicable to such capacity must be determined. According to Article 5.1a of the New York Convention, enforcement and recognition of arbitral awards may be refused if the parties concluding the agreement were under incapacity according to the law applicable to them. Thus, according to commentaries on the New York Convention, such as the one presented by Professor Rainmar Wolf, the law applicable for a corporation to enter into an arbitration agreement according to the New York Convention is the law of its lex corporationis, which under this agreement is the law of Equatoriana. This determination is also supported through Equatoriana arbitration law itself, as it adopted Article 5.1a as a basis for its own rules on recognition of arbitral awards. This is the law applicable on respondents' capacity to form the said arbitration agreement is the law of Equatoriana. And accordingly, according to Article 75 of Equatoriana's Constitution, contracts concluded between state-owned entities and foreign entities can be subject to arbitration only if Equatoriana's parliament consented to making the contract subject to arbitration. Thus, according to Equatoriana's Constitution, Mr. Barbosa, respondent's Minister of Natural Resources and Development, his sole consent on the formation of the arbitration agreement does not validate it. Moreover, this constitutional provision is also applicable, as according to Article 5.2b of the New York Convention, recognition and enforcement of arbitral awards may be refused if such awards are contrary to the state of enforcement's public policy. And according to the Belize Bank Limited case, as I quote from the case's verdict, since the fundamental national standards and the scope of governmental powers are established within every state's constitution, provisions of the constitution are indeed rendered as a matter of public policy, falling under Article 5.2b of the New York Convention. Thus, as Equatoriana is the is the place of enforcement of the possible arbitral award, a respondent can rely on its constitutional provision to contest the validity of the arbitration agreement.
Counsel, I'm sorry to interrupt you.
Yes.
I have a few questions for you. Can you please
Yes.
open page number 12 of the case file?
Yes, sir, I'm with you.
Okay, in the bottom right, I see a signature from Mr. Barbosa. This is the minister of which you speak?
Yes, the Minister of Natural Resources and Development, yes.
Very good. So he signed the contract, yes?
Yes.
Is his standard practice to sign invalid contracts?
Yes, he is the chairman of the supervisory committee.
So his standard practice is to sign invalid contracts.
Yes, but not arbitration contracts. He doesn't have the authority to form arbitration contracts, but he has the authority to form normal contracts under respondent.
So does he usually sign contracts that are not valid?
Invalid contracts?
Yes, that is
no,
my
he
question.
doesn't.
Does he have a standard practice of signing things that are not binding?
No, he doesn't.
Okay, so usually he signs things that are binding.
Yes, sir.
And he is the person who is responsible for speaking on behalf of your client, yes?
Yes, sir. Yes.
So how is he not an agent of your government? And if he is an agent of your government, doesn't the principles of agency law permit us to conclude that because he signed this, he could in fact speak for the government as a minister of the government, and that therefore his signature is indeed an indication that the contract is valid, is enforceable, and binds your client to arbitration?
Sir, yes, the minister is an agent of respondent, but at the same time, he does not have the authority to replace the constitutional provision requirement embedded in Article 75 of Victoriana's Constitution. Yes, he has the power to assure claimant of the constitutional provision, but and sign the agreement, but he doesn't have any power to validate arbitration agreements.
But under the theory of apparent authority, which is one of the principles of agency law, if the counterparty believes that you have the authority and that belief is reasonable, then you would be bound by the obligation to enter into arbitration. That is a principle of agency law, sir.
Yes, sir, but if I could please refer the tribunal to the witness statement of Ms. Horatia Porter, found in page 18. Page 18, paragraph number 6. This is the legal representative of claimant. It reads, at the same time, my understanding was that the agreement as a contract for public infrastructure required an approval by the minister in charge, which was in this case the Minister of Natural Resources. In addition, an approval by Parliament is required if such contracts contain an arbitration clause.
Very good, sir. But on paragraph 9, which is immediately below,
yes,
it states in the last sentence that the minister had assured him that parliamentary approval was just a formality and would be forthcoming. Is he a liar, sir?
That could be. The minister saying that that is a mere formality does not amount to that sentence invalidating the constitutional requirement. Claimant, Mrs. Horatia Porter is a member of a legal team of claimant, and she must know that the mere words "a mere formality" do not amount to neglecting or invalidating the constitutional provision. It's still a matter of public policy of the place of enforcement of the arbitral award, and has to be respected according to Article 5 of the New York Convention.
Yes, but I mean, the award could be enforced in a variety of different jurisdictions. If I'm not mistaken, there are 178 jurisdictions that are signatory to the New York Convention. Anywhere where your client might have assets or credits or any sort of other assets would be in play. your jurisdiction is not the only place where enforcement is possible.
Yes, sir, but it's the most place which is likely for the award to be enforced, as the subject of the agreement is actually found in that place in Equatoriana.
Okay, sir. So my final question for you on this point is this assurance that the minister gave, that the minister, who is a representative of your government, who you admit as an agent of your government, means absolutely nothing. That is your position as you sit here today.
First of all, the minister did not fully assure claimants that constitutional provision was inapplicable. The statement you, Mr. Presiding Arbitrator, referred us to, stating that it was simply a mere formality, doesn't show that he said that it was inapplicable. Moreover, claimant had always moved on with asking about the parliamentary authorization and the parliamentary debates time. So claimant knew of the parliamentary authorization and wasn't actually misled by the words of the minister. He actually always knew of its applicability to the agreement at hand.
Wonderful. Counsel, I appreciate that time is of somewhat of the essence here today. But I unfortunately still have one point of clarification on which I require you to opine on. And then after which I would kindly request that you proceed to your second point of presentation. But if you wouldn't mind, can you please go to page number 22 of the case file?
Yes.
That is claimant exhibit number C9.
Yes, I'm with you, sir.
Are you there?
Yes, I'm there.
Wonderful. This is an email from Ms. Queen. Yes, from Equatoriana Geoscience. That is your client.
Yes.
And this is an email that is proposing an amendment to the arbitration agreement you claim is invalid. So is Ms. Queen's standard practice to amend invalid agreements?
The amendment of the agreement didn't actually require the parliamentary authorization. So at that point, Mrs. Queen wanted to ensure that the agreement would fall in place or would fall in line with the respondents' views.
Okay, so if the amendment does not require parliamentary approval, isn't the amendment then in and of itself an agreement to arbitrate that would bind your client to this arbitration and therefore negate your entire argument?
No, but at the same time, for the parties to enter into the arbitration agreement itself that was amended, the entering into that agreement was in itself invalid. So therefore, the amendment obtained afterwards or made afterwards is also invalid.
Hence my question, is Ms. Queen's standard practice to amend invalid agreements?
No, it isn't, but her practice does not still does not amount to binding respondent to the arbitration agreement. As according to the New York Convention, Article 5, the constitutional provision would still be on top of the hierarchy.
Okay. I would take this opportunity to ask if my co-arbitrators Orlando and Sui have any additional questions on the point of jurisdiction.
No further questions, Mr. Chairman.
One additional question for me, leading on from all those other questions. You're suggesting basically that the minister, your clients, the minister and the CEO are able to enter into these arbitration agreements, this agreement, effectively in a way kind of misleading. I know you use the word they're not misrepresenting, but they know for a fact that they needed approval, but they didn't get it, and yet they proceeded. What is your position on that?
The minister had always ascertained to claimant that the parliamentary authorization would still have to be granted. So he always led claimant to the belief that the parliamentary authorization is still applicable to the agreement. And moreover, him failing to assure claimant or to notify claimant if this was the case, which it isn't. Him failing to do so does not accordingly invalidate that constitutional provision, as it's on top of the triangle of hierarchy according to the New York Convention.
I'll leave it at that for now. Thank you.
Thank you. Counsel, I appreciate that you have gone for 14 minutes now, and that you still have a second submission to present. I would ask that you do so in 5 minutes or less. Please move on to your second.
Okay, thank you, sir. I shall now move to my second submission, which is that the tribunal is obliged to stay the arbitrary proceedings. According to the FW Oil versus Trinidad and Tobago case, it is stated that proceedings should be stayed, as I quote from the case, if it is evident that if charges of corruption had been proven, it would have a most considerable influence on the opinion of the matter established by the tribunal. And accordingly, if it was proven by the public prosecutor in Equatoriana that Mr. Field had received corruption bribes from claimant, which is very likely, the agreement would be valid, as according to the separability doctrine, if corruption had been proven with respect to obtaining a contract, that would extend to the invalidity of the arbitration agreement falling within that contract. And through the record, it was stated that Mr. Field had been caught in corruption and convicted of corruption with respect to other cases. And it was also stated that claimant had also been convicted of corruption in past cases, as per procedure order number 2, question number 3, if I may please refer the tribunal to that.
Counsel, I'm sorry. The person that you claim was convicted of corruption, Mr. David Field, Teflon David, as he's called, who does he work for?
He works for respondent.
So he works for you. So your guy is guilty of corruption.
Yes.
And your argument is that because your guy is guilty of corruption, you get away from this arbitration.
I do not want to get away with that arbitration. I want to ensure the efficiency of these arbitrary proceedings, as if Mr. Field had actually been proven to be convicted with corruption, him and claimant, with respect to this contract, the arbitral proceedings would, the arbitral agreement would also be invalid. So the
excuse me, Councillor, but today there is no final judgment that has been the case where a judge has decided without any doubt that this person has been found guilty of corruption. So far, there is not such a final judgment, correct? In this case.
Yes, correct, Mr. Orlando. But per procedure order number 2, page 44, question 3, it was stated that there had been cases of corruption within claimant's company. And moreover, Mr. Blanchelli, claimant's COO, was also convicted of corruption with receiving money from offshore accounts. Right. So the 3 parties to the agreement were actually convicted with corruption with respect to other agreements. And according to ICC case number 1110, mere allegations of corruption, if they are indeed substantial, would extend to the invalidation of the arbitration agreement falling within the contract obtained with corruption.
Counsel, I'm sorry to interrupt you again.
Yes.
Can you please go to page number 33 of the case file?
Yes, sir.
This is your exhibit R2.
Yes, I'm with you, sir.
In the bottom right of the page, I can see information that the investigation is being conducted by a Miss Fonseca. Is that correct?
Yes, sir.
And it is correct that Miss Fonseca's sibling-in-law, I suppose, was part of the company Air Systems that was the bidder who lost to the claimant. Is that correct, sir?
Yes, that is correct, sir.
And it's also that Ms. Fonseca's son is actually engaged to your client's COO. Is that also correct?
That's also correct.
And it's also correct that there's an involvement between Madam Field, with whom you've represented before today, and she is also a cousin of Ms. Fonseca's son. So the point I'm trying to get here, counsel, is you expect us to believe that Ms. Fonseca is going to conduct independent investigations, even though her sibling-in-law lost the contract to claimant and her son is actually engaged to your client COO. This is the investigation that you want us to stop for.
Sir, if I may please refer you to a procedure order number 2, question number 44 of page 49.
Okay, I'm there.
Page 49, question 44.
Yes.
It reads that Mrs. Fonseca, she is one of the best known criminal lawyers in Equatoriana and has been one of the most vocal critics of the corruption within the previous government. Thus, Ms. Fonseca is actually a hater of corruption and a person who holds the rule of law very highly and wants to ensure that that everyone has his rights and there is no corruption within the government of Equatoriana. So she is indeed impartial.
Very well. Sui, Orlando, do you have anything in addition for Yusuf?
I do actually. Counsel, I've been listening very carefully to you, and you have had an answer for most things. However, it seems to me that what your case has been is that there are a lot of things surrounding this particular case and surrounding this particular arbitration agreement, but there's nothing here that so far links any of the issues that you deal with directly to this case. For example, the corruption allegations are with respect to other contracts, not this one. For example, Ms. Fonseca's reputation is related to a general reputation, not specific to this particular case. How do you deal with that? Because it seems to me that we've got a lot of fluff around it, but nothing absolutely direct. That troubles me.
Madam Arbitrator, it is stated by ICC case number 1110, which you just mentioned, that if substantial allegations give rise for a reason for believing that corruption was obtained in a contract, that would lead to having to grant a stay to the arbitral proceedings to ensure that corruption had not been contained with that contract, with obtaining that contract.
So my understanding, Counsel, I'm sorry to interrupt you, is that your entire reliance on all this also relies on this one case. Is that correct?
No, Mrs. Arbitrator. There's also the cases of the FW Oil versus Friedland case, which stated that that arbitral proceedings should be also bifurcated if corruption had been found, and that was supported by Professor Friedland.
All right, I'll leave it at that for now. Thank you.
Thank you.
Mr. Counsel, I have a question. So you said that mere allegations should be enough to stay the proceedings. Am I correct, if I understood correctly?
Yes, when they are substantial, when there are.
And how can we draw that line? Because any party in any arbitration can raise the point that corruption existed, and just to create guerrilla tactics and to stop the arbitration and make a nightmare of the arbitration, they may say there is corruption. So how this tribunal should draw a line between mere allegations and substantive allegations, I mean, what should be the standard to decide what is enough and what is not?
Mr. Arbitrator, the three parties to the case at hand had been proven to be convicted of corruption within the current case facts. As I referred the tribunal to the point clarification number 3, which states that claimant was caught in other corruption scandals. And if I also may now refer the tribunal to page 49, question number 40. It reads, the tax authorities in Mediterranean had been able to deduce from the leaked data in the Panama Papers that Mr. Blanchelli had 2 offshore accounts containing more than $8 US, which he hadn't declared in tax declaration. So that shows that even claimant's COO, not only claimant, had been alleged to be caught in corruption with regards to this contract. And Mr. Field had been...
Counsel, but to be fair,
Yes.
Mr. Kremer's witness statement, that is at page 13, paragraph number 7, states that the claimant did canvass its bank accounts and found no suspicious payments made. So that does not invalidate Madam Sui's argument to you that there's nothing specific. All of your allegations and accusations pertain to other cases, not this case.
And Mr. Chairman, if I may add, I believe that this is why there are ongoing investigations, because at this point, I mean, of course, there are some hints and clues that he had some wrongdoings, perhaps, but at least regarding this case, there is no compelling evidence that obligates us to stop this arbitration. So I'm perhaps going to my point. I mean, do you think that mere hints of past negative track records should be enough to determine substantive allegations, Mr. Cook?
Yes, I believe so. When the parties have been caught in such cases, and they're like your honor has just stated, the criminal investigations are still ongoing, and the results are pending. So that is a bigger reason to stay the arbitral proceedings, to ensure that the corruption scandal is solved first before moving on to deciding on the merits of the case, and then finding out that the arbitral tribunal might have no jurisdiction because the contract was tainted with corruption.
Okay. Thank you, counsel. This has been very helpful, very illuminating. I think we've had enough from the respondent. It's time to proceed with the claimant.
Thank you, Mr. President, members of this arbitral tribunal, opposing counsel, and all people present today. Good afternoon from Mexico City. My name is Ángel Sánchez, and alongside with my co-counsel Diego Aguayo, we're speaking on behalf of the claimant, Drone-I PLC. So, before heading into the arguments, I would like this arbitral tribunal to follow me on 3 ideas during my presentation. The first, it's validation. The second is ratification. And the third, as recalled by Madam President, is lack of evidence. So it's very important to state that just to give a realistic overview of what is this case about, we would like to point out that this is a case concerning the validity of the arbitration clause contained in the purchase and supply agreement signed between the parties. Now, 2 facts can be related to this, and it's very important to point it out before we get into the arguments, which is that in the first place, we do not deny that Mr. Field is under 2 charges of corruption, but in the first place, there is a distinction between being charged and convicted for cases of corruption. Mr. Field is only being charged for these cases. And the second is that these charges are not related to our agreement. Moreover, in relation to the parliamentary approval, we need to take into account that the Parliament knew about the signing of the agreement from spring of 2021 and has not given yet an approval of this parliament. We'll get to that further on in the question of ratification. But with that in mind, we would like to submit two issues as in answer to the respondent allegations. The first is that there is indeed a valid arbitration agreement between the parties, as the principle of validation applies, and therefore the applicable law to the present case would be Danubian law for the law of the agreement. The second thing is that the principle of ratification applies in this case, and the parliamentary approval can be considered as to be given to the claimant. And the third, in relation to the question of corruption, is that the standard has not been met for the question of the state of proceedings. So moving on to the first argument in relation to this statement of the applicable law for the arbitration agreement. So first of all, this is not a case brought before the courts of Ecuadoriana. This is an international arbitration. And as such, the principles of international arbitration must be applicable. One of them being the in favorem validitatis principle, better known as validation principle. Scholar Gary Bourne has already considered on this matter that the principle of validation can be defined as an interpretation of a certain clause within the contract with the aim of preserving its applicability as well as the intention of the parties. As you can see from this part, the correspondent contends that there is indeed a parliamentary approval that is needed for the validity of the arbitration agreement, and that according to the New York Convention, since it contends that the law applicable for this agreement, for this arbitration agreement is Ecuadorian law, it cannot be considered enforceable, a possible award on the grounds that it could go against the public policy or the legality of the state of Ecuadoriana. However, a case that can give us some light on this matter, it's the Missouri case of 1889, brought before the Court of Appeals of England and Wales. This case is very important because in that specific case, both parties accepted an arbitration clause under the laws of the United States. However, as a single requirement under this law, complaint considered that the validation of the agreement couldn't be given, they decided to resort to another jurisdiction that could validate indeed this arbitration agreement. And in that sense, since the law of the seat in that specific case was the state of the UK, they consider that applying the validation principle, the law governing the arbitration agreement should be the English law, which is the applicable thing in your case. What the parties always consider, and as it was pointed out by Mr. President, it was that they wanted to give our intention, they intended to give jurisdiction for this arbitral tribunal, not only in the arbitration clause, but on the subsequent addendum that was signed either by Ms. Wilhelmina Kremer, which is the CEO of the respondent, as well as from Ms. Horacia Porter, who was also part of the legal team of the claim. These two people are not related in any case with the cases of corruption that may be alleged by the respondent. And not only that, but they consider this a scenario, even though way before the signing of the agreement was given. So this can be not only considered as an intention of the parties to submit this to arbitration, but a confirmation of this specific matter. So,
Counsel, I'm sorry to interrupt you. Can you please go
Yes.
to page 18 of the case file? That is
absolutely.
your exhibit number 7.
We're here.
This is a witness statement of Ms. Horacia Porter. Yes?
Yes.
Who is Ms. Horacia Porter?
Mr. President, Ms. Horacia Porter is part of the legal team of the claimant on this matter.
She's a lawyer then.
Indeed.
Paragraph 6. She states that the agreement required an approval by the minister, which we have. And the last
Yes.
sentence says that in addition, an approval from Parliament is required if such contract contains an arbitration clause.
Indeed.
This is your client's position that an approval was required. Yes?
Our contention here is that we knew about this specific requirement and we're not denying it. It's crystal clear from the facts.
I'm not asking whether you knew it. I'm asking you whether the approval was required. That is a yes or a no.
Yes, Mr. President.
And it was not obtained.
No, it was not obtained.
So the actual question that I want to ask you is, was this not a business risk that Mr. Blunchley and your client have taken and that didn't pay off?
Well, not necessarily, Mr. President. We consider here that in the first place, it was not on the obligation of the claimant to submit this question to the Parliament of Ecuadoriana. First of all, because we're a foreign company that doesn't have the power to submit this kind of issues to a foreign parliament in another state.
Yes.
Moreover,
The argument that you didn't do the impossible is not a very good one, counsel. You knew that the approval was required. You knew you didn't have it, and you proceeded anyway. This is on you and your client.
well, if that could be the case, and this arbitral tribunal considered that one way or another, this parliamentary requirement was needed, it is our submission.
I mean, this is not how whether we consider it or not. This is your client's position, your client who is a lawyer's position, that the approval was required and that it was not obtained. Then why are we talking about it?
Well, we accept this part of the case and this question given by Mr. President. We do not deny the requirement of the Parliament approval on this matter. However, under the rule and under the theory of ratification, we may find that actually the Parliament had given its acceptance on this matter. For example, we can recall the case of Dramatic versus Neil Harper before an award from the American Arbitration Association of 2019, in which
Sorry.
it was
Can I just
explained.
interrupt that a moment? Just picking up on what you said. You said that Parliament ratified this. Before you go to the cases, how so? How did they ratify it?
Madam Arbitrator, we consider that under the laws of Ecuadoriana and as stated by the respondent, it was in the first place an obligation of the Parliament to give a positive action or an explicit acceptance of this arbitration agreement once they knew about this requirement of the arbitration agreement. So there is this question that the Parliament knew specifically knew about the signing of the agreement from spring 2021. On this matter, I shall refer this arbitral tribunal to the witness statement of Horacia Porter that can be found in page 19, paragraph 14. So
No,
in
I'm
this
sorry,
part,
paragraph 14?
14 and 15, Mr. President. In the paragraph 14, you will find that they had previously a context. They had a meeting with the respondent on this matter, and they accepted some changes in the arbitration clause.
Okay.
But more importantly, is that
let me stop you there, counsel. Paragraph 14 is talking about when respondent proposed changes to the arbitration clause. This does not in any absolute way respond to Madam Sui's question, which is how is it that Parliament approved the arbitration agreement?
I beg
This
your
does
pardon.
not answer that question at all.
I beg your pardon. It's in the second part of the state of the paragraph 15, where they say that he managed to put that up for parliamentary debate, which was to take place in early June 2021. This is very important because this debate actually happened, and on that specific moment, the Parliament knew about the signing of the arbitration agreement. And under the theory of ratification, the parliamentary was under an obligation of a positive action to deny the application of this arbitration agreement. They knew, and they had a reasonable period of time, as from this moment to the day of to today, there has been no mention from the Parliament of this statement. So we understand that this requirement of the Parliament may be applicable to our agreement, but yet the Parliament has not given any.
Sorry, counsel. That is a misleading representation of the facts that you have just given to this tribunal. Paragraph 15 is referring to a debate that is a theoretical debate as to whether or not there's a widespread anti-arbitration sentiment in part of this campaign. And what has been put for debate, he managed to put that up for debate. The debate is submitting to decisions of foreign private persons without any democratic legitimization. They used our agreement as an example of that general discussion. What was up for debate was not whether to approve the arbitration clause in this contract. That was not up for debate, and that is contrary to what you've just stated this tribunal.
Well, if you could
recount your explanation of the facts.
I would like to, Mr. President. It's in the last part of the paragraph where it says that in this part, they mention explicitly referring to the clause in our agreement as an example.
Yes,
So-
but as an example of this overarching widespread discussion, it was not a debate about whether or not to approve this clause in this contract. So
Absolutely.
this clause in this contract was not put in place for debate in Parliament.
It was not. But the thing here we need to
But you
consider
just
is,
stated that it was.
well, in this part, we need to know that the Parliament knew in this moment that there was an arbitration agreement signed, and therefore they had to take some action eventually to decide to accept it or not. That's basically how the theory of ratification applies. Yes.
Counselor, am I correct to understand what I'm hearing from you? Basically, you're going on the basis that silence equals consent type argument. Is that right?
Indeed, Madam Arbitrator.
And how does silence equals consent translate into the need for a positive approval from Parliament?
Well, Madam
I
Arbitrator,
have difficulty with the extrapolation, you may call it.
I understand. The theory of silence by acquiescence is that if there is an obligation to make a positive action, which in this case would be the Parliament having to explicitly agree or not on the matter, the question of silence, it's a definition. Well, it can be implicitly consented that the Parliament actually approved this agreement. However, due to questions of time, I would like to submit that if this is not the case.
Let's not worry about the time for now.
All right. Well, thank you, Mr. President. Giving more background to this matter. It was in the case of British citizens versus independent, that this theory of positive obligations, by not acting on those grounds, could afford to an intent of acquiescence by silence. We understand that the theory of acquiescence might be also applied in international public law, but it also refers to international arbitration for the question of when a party has an obligation to make a positive action, and by not doing it, it's accepting its application by consequence. And for those grounds, we believe that there is a valid arbitration agreement between the parties and that this arbitral tribunal does have jurisdiction. So as I see that my time is up, I would like to ask this arbitral tribunal to give me 1 minute for summarizing the question of the procedural issues.
Oh, no, we would like to hear the second argument on the stay and bifurcation. We would kindly ask that you, actually, before you proceed, Orlando, Sui, do you have any additional points on jurisdiction before we move on to the second point?
No further questions at this time, Mr. Chairman.
Nothing for now, thank you.
Thank you. Okay, so then as we proceed to the points on stay and bifurcation, counsel, we would, as we've done with your friends at the respondent team, we would kindly ask that you attempt to make your presentation within 5 minutes.
Absolutely, Mr. President, thank you. And on this matter, the respondent has submitted that a stay of proceedings can only be granted if there is corruption in the present case. In fact, it had recalled the ITC case 1110 to submit that in questions of public policy and corruption, if there could be found that an agreement is tainted by this corruption, there should be a stay of proceedings. However, we must take into account, first of all, that this is not the applicable standard, neither for corruption, neither for a stay of proceedings, and definitely not for bifurcation. In the first place, we consider that the question for the burden of proof of corruption in this case would be the clear and convincing evidence, as stated in the case of Alexander Brothers versus Alston. Now, this is with the intention of taking into account the nature of corruption and addressing that it's not only about bringing some facts, but to bring more than mere allegations and to bring clear and convincing evidence. So we're not here to make the case for the respondent in this matter, to address the questions of corruption. We're here to contend that as the respondent could not prove that there was corruption in the agreement, it could not have fulfilled the standard of clear and convincing evidence. And in any case, it could have done that. We consider that the principle of separability can be applicable, as it did not refer to corruption in the arbitration agreement. In the question also of staying of proceedings, we need to recall that first of all, this tribunal does have the power to decide on that matter, according to Article 17 of the PCA rules. But on that matter, they also need to take into account whether or not there is a serious relationship between the evidence that the respondent wants to submit to this arbitration. And in the second place, whether or not the length of the procedures and investigations could amount to a denial of justice to the other party, or to a delay on this justice. So, as Madam Arbitrator has pointed out, and as we can see explicitly from page 29, paragraph 16 of the case file, in response to the notice of arbitration, Mr. Field has been charged in the first place for 2 cases of corruption of 2 contracts in the context of the Northern Part Development Program. However, this is not related to our case. And more importantly, those 2 charges were made in a time lapse of 4 months. However, Ms. Fonseca, the special prosecutor on this matter, has requested that to stay proceedings until the investigations are done by the end of 2023, amounting to a total of 17 months. It seems unreasonable to consider that they could have done 2 charges of corruption in 4 months, and without giving any reason, they decide to stay proceedings for over 4 times the time they wanted to stay, the time they take to make the first 2 charges. So on that ground,
I
yes.
understand your argument. I have another point that I would like your clarification for me. Mr. Blunchley, he used to work for your client, yes?
Yes,
He was the person who negotiated the contract on behalf of your client, at least until it was closer to the end.
yeah, Mr. Blunchley was the CEO from the claimant and the main negotiator from this part.
So he would be the person most knowledgeable on your client regarding these negotiations, yes?
We admit that Mr. Blunchley.
Please
was
answer my
meeting-
question. Was he or was he not the most knowledgeable person on your client?
Yes, he was.
Why is he not here? Why is there not a witness statement from Mr. Blunchley? Or did I miss it? Is it in the record?
Yeah, well, in the first paragraph of William Primer, it is stated that he was detained for tax evasion.
No, I'm asking you, why is Mr. Blunchley not participating in these proceedings?
We consider, first of all, that well, we really don't have in the case file any relation of why Mr. Field. I now understand your question. It's
I
in
think we
relation.
do, counsel. I think we know why he's not here.
Yeah,
I want you to say it. Why is he not here?
because he has requested a payment for bribery in order to participate in the proceedings.
And you're not paying him. That's why he's not here.
Indeed.
Okay. So if he's not present, this means that the respondent is not going to be able to cross-examine Mr. Blunchley and ask him if he got paid or not.
Yes.
This tribunal is not going to be able to ask him for his tax returns, for his documents, for his bank accounts, for monies that he has received. We will not be able to talk to him at all.
Indeed, on that matter, which
How
is tax
exactly do you expect the respondent to be able to demonstrate that Mr. Blunchley was bribed or bribed someone for these contracts if he's not here, if we have no documents from him whatsoever, and there's no way to make him participate?
Mr. President, we expect this respondent to submit its case according to the other respondents in other cases of arbitral awards regarding corruption. For example, we can recall many cases.
Does Mr. Blunchley live in Ecuatoriana?
We don't have information of that specific fact of where does Mr. Blunchley.
Where is your
lives in.
client from?
My client is from the state of
Mediterranean?
Mediterranean, indeed, Mr. President.
Wonderful. So presumably he lives in Mediterranean.
Indeed.
So if he does not live in Ecuatoriana, and if there are no facts indicating that he lives in Ecuatoriana, how do you expect courts from Ecuatoriana and Ms. Fonseca as the prosecutor to be able to obtain information, testimony, documents, and depositions from Mr. Blunchley?
On that matter, we do not expect that the respondent may have an opportunity to address the questions on the tax evasion of Mr. Field. However, we must take into account that
I'm not asking
even
you
though
about Mr. Field. I'm asking about your former representative, Mr. Blunchley, who is
Indeed.
supposedly, who is in the respondent's perspective, the guy who was responsible for bribing their people for this contract. He is not here, and they will not have their documents in these proceedings. We will not see him. We will not ask him questions. How will they possibly present their case if we don't wait for the allegations of corruption to be concluded?
Mr. Field, Mr. President, as recall in the case of Rutas de Lima versus Municipalidad de Lima, the question of corruption requires somehow the use of circumstantial evidence. In most cases, there is not a possibility for the arbitral tribunal to assert for criminal judgments or witnesses because of the nature of bribery. So in those cases, as is in your case, we can take recourse to circumstantial evidence that may not only refer to the witness surrendered by the respondent or the claimant, but also to all the other circumstances in this case. So in that specific matter, Mr. Bluntschli would be only one of those circumstances. And even in talking about Mr. Bluntschli, he's not a participant, a protagonist on that specific objection to jurisdiction, as respondent realized that the main causation of bribery was from Mr. Field. And
wonderful.
because
Then let's take your argument at face value, counsel, and let us take then circumstantial evidence, shall we? The circumstances indicate that the negotiations changed fundamentally after there was a meeting involving Mr. Field and Mr. Bluntschli, in which the contract, the duration of the services for the contract expanded from 2 years to 4 years. The payment increased by 25%. And all of this happened in the one meeting that was not documented, and it was only between the two gentlemen who were not present. Is that not circumstantial evidence enough for us to understand that there's something fishy happening here?
Well, that could be a possible scenario, but we need to remember that the source of that information is the witness statement of Ms. Leonida Bourgeois. First of all, Ms. Leonida Bourgeois is a statement submitted by the respondent. So there are grounds to believe in the first place that it's self-serving evidence. And more importantly,
counsel, I'm sorry to interrupt you there, but the rules of the moot state that everything that's contained in the case record is to be taken at face value, yours and theirs alike.
We understand that the procedural rules may decide that on that specific matter, but we need to recall that Ms. Fonseca, but in that circumstance, from the case file, indeed, there are contradictory information on this matter. First of all, because we can take into account that Ms. Fonseca is the fiance of the son of the prosecutor of Ms. Fonseca. We can take recourse that it's a witness offer from the respondent. And even though we can rely on its credibility for these grounds, there are no grounds on the case file to confirm this information. So we cannot rely on that specific circumstantial evidence to consider that the highest standard of proof of clear and convincing evidence have been fulfilled. For these matters, we submit that the circumstantial evidence can provide light on this matter to submit that there is not enough to provide for a clear and convincing evidence, and therefore that the agreement is not tainted by corruption. And lastly, in relation to the bifurcation of these proceedings, we must take into account that since there is no relation, there cannot be also a bifurcation, taking into account the standard given in the case of Glencore versus Bolivia of 2018. In that specific case, a three-standard requirement was needed, in which, as a cumulative standard, claimant only needs to deny one for this tribunal not to grant bifurcation. The last one, in relation to the prima facie seriousness of the allegations of the jurisdiction, can be considered as denied. In the first place, because, as pointed out by this tribunal, there is no relation between the charges of Mr. Field to our agreement, and therefore, there should not be a stay of the proceedings or bifurcation. So, if I cannot be of further assistance for this tribunal, I shall thank you for your time and your attention.
Mr. President, if I may. Counsel, I'd like to circle back to one of the first few questions asked by Mr. President, which is that there seems to be an overwhelming feeling that I have here that the claimants went ahead at their risk to take a chance. That chance didn't turn out in the manner that they had hoped and are now seeking to claw out of it by very, very technical arguments. There is still this element of blowing hot and cold here. Can you please address me on that? I remain troubled by that despite all your specific arguments.
I beg your pardon. I think Madam President is referring to the question. I couldn't hear you properly. I beg your pardon. Could you please repeat your question?
Yes, of course. right at the beginning, Mr. President talked about the claimant having taken a chance in signing this agreement, knowing that there was no approval from Parliament. And now, despite that, that chance did not work out very well, and you are facing this issue, and that you are relying on very technical arguments to proceed with this arbitration. I still have this feeling of you blowing hot and cold. I want this, but I don't want this. And you have got technical arguments, but I still have this overwhelming, overarching discomfort with that. Can you please help address that? Thank you.
Absolutely, Madam Arbitrator. I understand your concern. So on this matter, we must refer that arbitration at the end of the day, it's a matter of contract. And by definition, a contract, it's a matter of consent. So we wouldn't have jurisdiction for this tribunal if the parties never accepted such or give their intention to be bound by this tribunal. So we consider here that, as it was stated as well by Ms. Gracia Porter, the parliamentary approval, as stated by the Minister of Natural Resources and Development, Mr. Barbosa, was only a formality that would be given before Christmas break. Two elements can be found on this. The first is that it was only, this was not disregarded, it was not considered by the parties as a factual element in relation to the consent to be bound by this arbitral tribunal, but rather a formality that the second point would be eventually be given. We have already made our analysis in the question of ratification, but the thing here that I want this arbitral tribunal to consider, and in relation to Madam Arbitrator question, is that it is crystal clear that the parties always wanted to confer jurisdiction to this tribunal, regardless of all the question of corruption, as the two people that were not charged for cases of corruption have ratified, have confirmed this intention by the Exhibit C9 in relation to this addendum to the arbitration agreement. So we consider here that the claimant is not taking advantage of the respondent, but rather it's only making reliance on the statements that and on the belief that both parties always wanted arbitration.
Can I seek a clarification here? As I understand your argument in relation to my question is that, number one, that the representation that the approval of Parliament is only a formality, that representation overrides the actual requirement. Secondly, that the intent of the parties for arbitration also overrides the requirement for parliamentary approval. Am I correct to understand that is your gist of your argument?
Indeed, Madam Arbitrator, we contend that yes, we need to take into account the commercial nature of this dispute. This is not a case brought before an investment dispute resolution case. This is not a case between a company and the state, but this is rather a commercial arbitration between two companies that at the end of the day, its consent was only to be given by the CEOs of those commercial parties. For that reason, we consider that yes, we need to take into account the nature of the commercial arbitration, and therefore that this requirement of the Parliament may be a little bit too much for that intention of the parties. Thank you.
I'll leave it at that for now.
I have just one quick question. So we have heard opposing counsel addressing the theory that we do not need, as you have said, compelling evidence, or I don't remember the standard you said, but they said that we needed to have sufficient, was that the word, Mr. Cook, sufficient evidence, or what was the standard you were addressing?
Substantial evidence, sir.
So substantial evidence. So substantial evidence, and you are on the opposite side. So why do you think that we should follow or accept your standard instead of the substantial evidence standard that they have set?
First of all, Mr. Arbitrator, I think that it refers to the question of bifurcation in that specific matter. When Mr. Arbitrator asked the respondent, where was the line between arguing cases of corruption just to bifurcate the proceedings? And we can find actually that this was taken into account in the case of mainstream renewal versus Germany, in which they considered that the standard to be applicable was to be prima facie serious. So this means, according to the case of Red Eagle versus Colombia, that this objection to the jurisdiction, in this case corruption, had to be at least for a serious purpose for this tribunal and not vexatious, as it was recalled, but meaning that there could be indeed some relation between that specific bifurcation and the objection to jurisdiction. We have stated that Mr. Field, even though all the allegations of corruption, is not related, those allegations, to the case in particular. So the standards are different for the objectives to be followed. And in the question on why the standards are different, it's on that specific matter. We consider that the question for proving corruption is to provide indeed a clear and convincing evidence for the agreement, while the question on the jurisdiction, it's only a prima facie serious objection to the jurisdiction.
Thank you.
Thank
Thank
you,
you.
Counsel. It's interesting that you've, in response to Madam Sui's question, stated that we should not take into account investor state cases because this was a commercial case. And then in response to Mr. Orlando's question, you backtracked on your former statement and stated that we should. But I would kindly ask Mr. Youssef if you can limit your rebuttal to 1 minute. You're muted, sir.
Yes, definitely, sir.
Please go ahead.
So through these current pleadings, claimant directly and explicitly stated that it agrees that Article 75 of Equatoriana's constitution is applicable to the agreement at hand, and thus it knew of the parliamentary approval requirement for the inclusion of an arbitration agreement in the contract. Thus, how could it simply still argue that the arbitration agreement is valid after making such claims against its own? Thank you.
Thank you, sir. Mr. Sanchez?
Thank you, Mr. President. Only one point on rebuttal. The respondent did not pay attention to the question of the validity of the validation principle to be applicable for the law of the arbitration agreement. And if we take into account that in this particular case, that specific element could invalidate the arbitration agreement, it's according to this principle, we need to take into account the law of the seat of the arbitration that doesn't have that requirement, and therefore that the validity of the arbitration agreement can be found in this case. Thank you.
Thank you, sir. All right. I think we're all eager to hear about the merits of the case. And if the parties are maintaining their prior agreement, we believe we turn now to Mr. Aguayo. Is that correct?
Correct, Mr. President.
If you are prepared, sir, please, you have the floor.
Thank you, and good afternoon, Mr. President, and all members of this arbitral tribunal, deposit counsels, and all public present in this dispute. My name is Diego Aguayo, and I will be discussing the merits on behalf of Dronite PLC, the claimant in this matter, showing how the respondent is trying to avoid his contractual obligation by bringing flawed arguments regarding fraud and corruption. In specific, for the next 14 minutes, I will be addressing two main submissions. First, the CIG is the applicable law governing the substance of the agreement. And second, that the respondent is not entitled to avoid the contract under the grounds of the Equatorian law. To start, it is important for this tribunal to take into consideration that the parties conclude an agreement related to the purchase of 6 UAVs, also well known as drones. And it is unquestionable that both parties are contracting states of the United Nations Convention for Contracts on International Sale of Goods, hereinafter the CIG, that the CIG has an ex officio applicability regarding the substance of the contract by virtue of Article 1A. The relevant question before this arbitral tribunal is whether the 6 UAVs acquired by the respondent for the exploration and aerial surveillance of the northern region of Equatoriana can be classified as an aircraft within the terms of the convention. My submission will be divided in two main points. First, in reason by an historical interpretation of the convention, The Schedule Line 2010 cannot be classified as an aircraft since it was not required to register within the domestic law. And second, according to the intention of the parties, the Schedule Line 2010 do not fulfill the elements for a common intention for the common definition of aircraft. First, since the CISG does not provide a specific definition to what is to be taken as an aircraft, we have to follow the interpretation system that the CISG states is in Article 7.2 of the Convention, maintaining when the literal text is not enough clear to clarify the concept of the Convention, we shall follow the general principles and the preparatory works in the drafting of the Convention. We may see in the preparatory works that Article 2E of the Convention regarding this exclusion of aircraft, the relevant element to take into consideration was a duty to register according to the domestic law. This criteria was maintained in the rationality that different contracting states classified as in different matters the aircraft. Some countries classify as a goods that are under the scope of
Mr. Aguayo, I'm just looking at Article 7, and you said that Article 7 provides that parties should refer to principles, general principles, and to the preparatory works. But from Article 7, subsection 2 or section 2, I do not see where preparatory works fill in.
Mr. Arbitrator, this is that the Article 7.2 does not provide a specific question of preparatory works. Nevertheless, the interpretation that has been maintained by this article, as can be seen in the CISG case 999, judged by the German Supreme Court in the year 2002, was maintained this idea of the connection that we have to follow to complete the interpretation of the Convention and such gaps where is not clear the provision of the Convention. This was sustained also by Professor Kroll, and our professional in the interpretation of the CISG scholar, that this follows this strong line in the application of the interpretation of the Convention. In this idea, as the main source of the general principle applicable to the Convention is also the preparatory works in the drafting of the Convention, we have to look on the rationality.
Thank you. That's enough.
Yeah, but actually your answer pronged the question for me. You're looking at mechanisms for interpretation of the Convention
Yes.
when interpretation of the Convention is necessary, right? Why not use the dictionary? I'm looking at the dictionary right here, and it says that an airplane or an aircraft is a vehicle for traveling or transporting through air. Is that not what your drones do?
It's a part of what drones do, but this classification of aircraft within the dictionary that Mr. President mentioned is not enough to lie the general principle of the Convention. Article 7 also
says who? The word aircraft speaks for itself.
The word aircraft has a special meaning gave within the terms of the Convention. We cannot take in any specific definition of aircraft. We have to resort.
Is this your opinion, that the word aircraft does not mean the definition in the dictionary for aircraft? Where is this coming from?
Mr. President, this is coming from the strong scholars that follow this line. Professor Spencer, current member of the CISG Advisory Council, alongside as Professor Vizcasillas, current president of the CISG Advisory Council, has maintained that this exclusion of aircraft is not absolute. And the interpretation of these ideas of provisions
So Professor Spencer is against the dictionary. That's what you're saying.
No, Mr. President. Professor Spencer is lighting what is the intention from the drafting of the Convention to follow this exclusion of aircraft.
But isn't the wording as contained in the CISG the best evidence of what the drafters of the CISG intended with the CISG? That's why they wrote what they wrote. They wrote aircraft. What does aircraft mean? Aircraft means something that flies.
Just picking up on what Mr. President is talking about, what I'm hearing is that you're arguing an aircraft is not an aircraft because it suits your case. So can you address his questions within that context?
indeed, for these members of this arbitral tribunal, I will reverse the question of the Mr. President. The definition of aircraft is to be taken into consideration the autonomous interpretation that we have to look from the CISG. This was maintained by the CISG case 1377, judged by the Austrian Supreme Court in the year 2006, maintaining that we have to exclude all the definition and all the preconception that the domestic bodies or different international criteria is taken. And the first resource that we have to take into consideration is the own CISG, its general principles, and the drafting of the convention. By this criteria, the rationality of the creation of Article 2E is the relevance according among the all other definition of aircraft. In this, the two elements that a duty to register and the intention of the parties to transport goods and humans, and the relevant element for the classification of aircraft as it was intended by the Article 2E in the drafting of the convention. First, we can see that—
Before you go there, I still have questions that before you go to domestic law, which it's contradictory to me that first you tell us that we need to look at the CISG independently, and then you want to talk to us about whether registration is or isn't necessary. We'll get that to a minute. What is it exactly that you're selling? What is the product? What are the goods that your client is selling? You said UAS. What does UAS mean?
A UAS means an unmanned aerial system.
Aerial.
Aerial, indeed.
Something that moves through the air. Something that flies.
Indeed.
So these goods fly.
Indeed.
They carry cargo.
No, Mr. President.
They do not carry cargo.
They were not intended to carry cargo, and by the specific custom required by the respondent, occupying the payload of 245 with
Counsel,
the
please go to page 15 of the record. Please open page 15 of the record.
The page 15 of the record clarifies the general product information of the Kestrel I-2010.
Sure, I know. I'm looking at the bottom of page 15. I'm looking at something that looks a lot like a helicopter.
Indeed.
And it's talking about a capacity to carry a payload of 245 kilograms.
Indeed.
How would you call the 245 kilogram payload that this thing is supposed to carry, if not cargo?
Because, Mr. President, we have to take this payload within all the contextual background that the parties fixed for their agreement. And for this question, I would like to drive the attention of this tribunal to the page 45 of the record. We can find in the specific page, in answer to question number 10, that from the line number 2, that from the second line in the answer to question, we will find that by the specific custom required by the respondent with the aerial surveillance equipment option, there is hardly any weight and volume capacity left, even if the Kestrel I-2010 has a payload of 245 kilograms. The specific set maintained to the purposes of the respondent eliminates its capacity to transport goods and human, stating that taking into consideration this relevant element to transportation of cargo cannot be fulfilled by the Kestrel I-2010 in the specific custom maintained by the respondent in this contract.
Counsel, please read the first line in the answer to question 9 in the page before.
I quote, yes, okay, question number 9. Are any drone eye PLC UAVs capable of carrying humans or cargo regardless of their intended use? Yes.
Please keep reading.
Yes, both the Kestrel I-2010 and the Hawk 2020 are able to carry other cargo fitting into the front of the payload base instead the surveillance equipment.
You just said in answer to my response, in my response to my question, you've stated that this drone was not capable of carrying cargo. Do you want to recount your answer to my question?
Mr. President, Mr. President, our statement will be stated in this criteria of the contextual background and the intention of the parties. We will see that the only manner that the Kersolite can carry this cargo is by this equipment, this surveillance equipment into the payload that can be maintained, but the only intention for the respondent was in all moments this aerial surveillance. And it's criteria that the transportation of cargo is not needed from the respondent, and that this disregarding of the surveillance equipment will not maintain through the contract and was not the substance of the idea from the intention of the parties. In this,
Council, sorry, I'm just coming back again, listening to your answer to Mr. President's question. There seems to be a distinction between what the UAV is capable of versus what the intention of the parties are. And you seem to be mixing the two together. Can you assist me with being a little bit more clear on the distinction? Thank you.
Indeed, Madam Arbitrator, there is a distinction that we're discussing in this time. There is the matter of capability and there is a matter of intention. The CISG, in the classification of what is to be taken as an aircraft, to disregard this exclusion from the convention is a matter of intention and is not a matter of capability. It's not a coincidence, members of this arbitral tribunal, that between all the bidders applicable from the call for tender, the respondents select the claimant. And well-known special priority in the development of the UAVs for the aerial surveillance, that the respondents select the Kersolite 2010 and design a structured UAV model for the aerial surveillance. And it will be unreasonable from the respondent to select the Kersolite in taking into consideration that the transportation intended UAVs are 30% cheaper than the one intended for aerial surveillance. These remarks and highlight intention from both parties to sustain that the intention of the parties was the aerial surveillance.
Council, I'm sorry to interrupt you. Can you please open your exhibit number C2 at page 10?
Indeed.
This is the contract, yes?
Yes.
Can you please show me where in the contract it states that the respondent intended to use this solely for aerial surveillance and not for the transportation of cargo?
Mr. President, we can find it in the recitals, in specific in the paragraph 3. At the end.
Please read it to me. I'm struggling to find it. Where is it?
In the paragraph 3, in the end of the second line, we will find the intention of the aerials of the unmanned aerial system. There is to collect the relevant geological and geophysical data for the proper exploitation of such natural resources. We can see that.
Very good. Now, can you please read into the record 2 areas below? Whereas in the process of negotiations.
Whereas in the process of negotiations, the scope of the agreement to be awarded was changed to reflect new developments and a possible additional use of the aircraft.
So the aircraft, it refers to them as aircraft. Isn't that convenient? And it actually refers to your goods as aircraft, and you're telling us that they're not aircraft. That's interesting one. But moreover, it says that it's going to be used for other purposes other than aerial surveillance. Doesn't the contract negate the argument that you are stating to us that we should look exclusively at the alleged intent that your client perceives on the respondent?
Mr. President, that is not our statement. The idea we're critiquing is the relevance of the primary intention of the parties, and not exceptional statements that do not transcend of what is the common intention from the parties. As we can see that the primary task to be taken into consideration by the Kersolite 2010 was only aerial surveillance, and it can appear from the record that it's only being used in exceptional manners. The Kersolite 2010 has been used from this transportation cargo. In taking this unreasonable from the Kersolite 2010 in the transportation criteria, for this transportation, as previously mentioned, that the UAV's model for transportation are way cheaper and more suitable than the Kestrel Light 2010.
Okay,
Members
guys.
of this, okay.
I see that we're extending ourselves a little bit on the time here, but before we're done with the applicability of the CISG, I still require your clarification on one point. But you've stated at some point during your presentation that the local requirements, that the local law of Ecuatoriana would not apply, because in order for something to be an airplane or an aircraft in Ecuatoriana, it needs to be registered. And in this instance, registration was not required exclusively because of the fact that the company is a state-owned company and therefore need not register. I want you to explain to me, I want you to open page number 32 of the case record.
Indeed, Mr. President.
Paragraph number 7 of the declaration, the witness statement of Leonida Bourgeois, states that in this instance, registration was not required because it was going to be operated by a state-owned entity. However, in the event that these aircraft were to be transferred to another proprietor that would not be a state-owned entity, that they would indeed have to be registered, and therefore it was crucial to have a clearly visible product number at the tail of the aircraft.
Indeed, Mr. President.
This does not then negate your argument that registration was not required, because here registration was only not required given a specific characteristic of the buyer, which incidentally, your co-counsel, Mr. Sanchez, told us to disregard the fact that this is a state-owned entity and to consider this exclusively as a commercial counterparty in a commercial arbitration. You are now contradicting your co-counsel and stating that we should take into account the fact that it is a state-owned entity. Please explain that point and then conclude your presentation.
We have to take into consideration this criteria of why the respondent is exclude this duty to register according to the Kestrel Light 2010. Professor Franco Ferrari has maintained from this interpretation of the duty to register that we have not to resort of a general interpretation matters, that we have to define it in a case-by-case basis. The elements from the administrative contract, according to the jurisdictional issue, are relevant, are different issues where different elements and where different standards are to be applied with other cases. We are containing here the substance and the merits of the case. Application from the fee that the parties made to the contract, we can see, and it is indubitable, that the respondent, being this part of the government, sustained to the claimant that this was not a duty to register, maintaining this that according to the substance, the CISG application, that we have to not to resort in this idea to the element to classify as an aircraft, maintaining that the UAV cannot be classified as an aircraft within the terms of the convention.
Very well, counsel. If there's anything in addition from Orlando or Sui on the first topic on the applicability of the CISG before we move on to the second.
No questions.
All right, counsel, I see that your time is well above what we originally set out. I would ask that you attempt to make your second point on the termination of the contract within 5 minutes.
And that will be, Mr. President. Moving on to the second point, it is a submission that the respondent is not entitled to avoid the agreement under the grounds of the domestic law. As a contextual background, the respondent is allegedly that the claimant commits fraud by not disclosing its ongoing in developing a UAV model, the Hawkeye 2020, that was fitted with different technology than the Kestrel Light 2010. Following and stating that the domestic law, the International Commercial Contract Act, Article 3.2.5 of Ecuatoriana, is applicable within the contract in the meaning of fraud and interpretation of the Ecuatoriana Supreme Court in the allegedly wide range duty to disclose. Nevertheless, we have to state that this domestic law is not applicable within the contract, neither this duty to disclose, in two main points. That first, the matters of fraud, the matter that is presented before this arbitral tribunal is not to be interpreted according to domestic law but it is must to be interpreted according to the CIG or in Arguendo by the UNIDROIT principles. And further, according to the commercial standards and fair dealing elements required for the duty to disclose, the claimant has not such duty. The first point, it has stated that yes, Article 4.1 of the CIG excludes from the interpretation of the Convention on matters of validity. Nevertheless, when the substance of the issue is the same as seen as the provision of the CIG, as the conformity of the goods, the CIG prevails, even if the matter in discussion is the CIG.
Counsel, please open page 12 of the case record.
Indeed, Mr. President.
Clause number 2 on the top of the page describes the circumstances in which the respondent is entitled to avoid the contract.
Mr. President, where is specific?
Page 12, paragraph number 2, for the avoidance of doubt, the following breaches shall be considered fundamental. Fundamental breaches allow you to avoid the contract. Article 25 of the CSG?
Yes.
Okay, good. Paragraph C says anything that deprives them of their entitled to expect under the contract.
Yes.
Who wrote this provision?
This provision was wrote by by our client.
By
It
you.
was modified.
Your client wrote this provision.
It was modified by our client.
Very good. So any doubts in the interpretation of this provision go against you, yes?
Not certainly, Mr. President, in the idea that this is not a standard term. This exactly provision go through a negotiation between the parties and for autonomy. And the interpretation is to be on the same level by both parts.
Very good. Still looking at the contract here, sir, I have another difficulty that I'm looking at. And the difficulty that I have is that the page before, the page 11, it says that the goods were supposed to be delivered in December of 2022, July of 2023, and December of 2023. Yes?
Yes.
The argument that you were making about whether or not the goods are conforming to the contract, at what time do we evaluate whether the goods are conforming to the contract or not? Is it when the contract is signed, or is it when the goods are delivered?
It's when this contract is signed. And this was maintained by the case Abu Dhabi versus Citigroup.
The conformity of delivery is measured not when delivery happens, but when the contract is signed.
It's the idea of the allegation of the respondent of an issue of fraud, and this criteria is to be determined that the statements are to be true in accordance with when the time of the contract was signed, and not what the contract is to be performed.
Yes, but evidently it is impossible for someone to ascertain whether the goods are conforming to the contract before they receive them.
Not certainly, Mr. President, because
Are they clairvoyant, sir? Can they see into the future?
No, Mr. President.
So they have to receive something in order to determine whether that something conforms to the contract. Yes or no?
Yes.
Excellent. When they were to receive these goods, therefore, in December of 2022, in July of 2023, and in December of 2023, would the aircraft that your client was going to deliver be the state-of-the-art unmanned aircraft systems?
For the purposes that the respondent is requiring, and at the time of completion of the contract, we state that it will.
Will it be the newest, the latest goods that you sell, sir?
Indeed, Mr. President, as can be seen from the obligation of the respondent, of the claimant, in Article 2 of the Purchase Supply Agreement, its obligation was to provide the newest.
Vender el state of the art en el momento del contrato, no en el futuro, justamente. Sí, exacto. Lo que tú dijiste. Ya si hubo después de desarrollos y eso. Pues,
I think there's some people.
Dice que yo vendo.
Pablo, I think your microphone is on. Yeah, thank you.
Okay, as we're stating, the obligation of the respondent with a literal interpretation of the contract is clear. The claimant has the duty to deliver the 6 newest Kestrel Light 2010. and this obligation of conformity of this interpretation, and that the respondent accepted this criteria to be incorporated according to provision and obligation from the parties, sustain that this idea of delivering the newest model is indeed applicable at the time of delivery of the contract. Stating here, we have to take in consideration that according to the CIAG case 254, even if this tribunal finds that we are looking here of a matter of fraud, we have to take in consideration that the CIAG prevails over the interpretation of the contract, and its remedy is to be applicable within this interpretation and not the domestic law. Stating here that the respondent is trying to argue that since its purposes cannot be complied within the case of 2010, it's clear that this is a matter more of conformity of the goods, whether the idea is to rely on whether the case of can fulfill this in the best matter or in the best technology, the exploration of the Northern Riviera Ecuatoriana. And without the argument is maintained, and I see that in my time from the statement of this argument has lapsed, we maintain that the issue of fraudulent misrepresentation is to be disregarded, since the conclusion of the agreement was not maintained of such false statement, neither this fraud or duty to disclose by the parties. Without any further to say, we want to request this tribunal two submissions. That first, to grant that the CIAG is the applicable law governing this tribunal. And second, that recognize that the respondent has no right to avoid the contract according to the contextual background of the contract. I thank this tribunal for your attention.
I have an additional question, please, Mr. President.
Absolutely, of course.
So I noticed from the contract itself that there is a merger clause, and I forget where it is now. Yes, so if I go to page 12 of the materials, and specifically to Article 21, that this document is the entire agreement between the parties. Now, it seems to me that this contract, which you signed, your client has signed, and included that merger clause at the request, I believe, of your client, and yet you seem to be placing a lot of emphasis on arguments that are surrounding the contract as opposed to specifically inside the contract. Can you please address me on this concern that I've raised?
Indeed, Madam Arbitrator. The merger clause that are applicable within the contracts in interpretation according to the CIAG are not to be disregarded the contextual background. This idea of the merger clause is to disregard all the negotiation and all the pre-contractual duties that are contrary to the statements and provisions that are inside of the contract. Such negotiation that supply or extend the criteria or clear the criteria maintained by this line of the provision of the contract are to be acceptable as interpretation of the contract is to be maintained. And this is stated in the CIAG Article 8 and specific Article 8.2, when all the negotiations are not to be disregarded, and only such that are contrary to the provision and obligation of the parties are the one to be taken off of the interpretation in this idea.
Thank you for that. The other question that I have is that I believe you're relying on Article 3.2.5 of the ICA, and it speaks to the word fraud. So what precisely can you pinpoint the issue that you are relying on to equate it to this fraud requirement of ICA?
Indeed, Madam Arbitrator, this issue of fraud, according to the Article 3.2.5 of the International Commercial Contract Act of Ecuatoriana, mandates this that the other party is entitled to avoid the contract when it's maintained by false statements, when there is not such duty to disclose according to the commercial standards and fair dealing. It is the claimant's statement that We do not have the duty to disclose according to the commercial standards and fair dealing provisions. As first we are maintaining at the time of the conclusion of the contract, we do not have this HUB 2020 being available to the market, that the relevant information of such UAV model was not given of any protection of any patent, meaning subsequently that this confidential business information is protected according to the trade secrets. In this idea, the party who is the property owner of these trade secrets has this wide range optional right to decide if to disclose or not to disclose this such information. Even in any moment, this duty to disclose this specific information, that just for the sake of to maintain to this tribunal, it was in any moment required to the claimant this duty to disclose and this application of the Article 3.2.5 of Ecuatoriana.
Thank you. Nothing for now. Thank you.
Thank you, Madam. Orlando, did you have anything further, or can we proceed to the respondent? Wonderful. All right. We finally arrive at our last presenter, Miriam. Are you prepared to commence?
Yes, I am.
Then please, if you're available, you have the floor.
Okay. Greetings, members of the tribunal. My name is Mariam Rabia, and I'll be representing respondent Equatoriana Geoscience on the merits of this case. I'll be speaking for the next 14 minutes, reserving 1 minute for possible surrebuttals. My speaking will be divided into two main submissions. Firstly, that the CISG is not applicable to the purchase and supply agreement, and second, that respondent can rely on its domestic law to avoid the contract. Starting with the first submission, respondent has two arguments. Firstly, that the CISG does not apply to the purchase and supply agreement, as the Castral I is a good excluded under Article 2E of the Convention, and second, that there is no registration requirement under the CISG. Starting with the first argument, the CISG is inapplicable to the purchase and supply agreement, as the Castral I falls under the exclusions of Article 2E of the Convention. As claimant has stated, both parties are contracting states. However, Article 1 of the Convention also states that the Convention applies to contracts of sale of goods. Article 2E of the Convention, however, includes an express exclusion of certain types of goods, which include ships, vessels, hovercrafts, and aircrafts. And as referenced by claimant, Professor Schwanzer has also stipulated that exclusions under the CISG, in accordance with Article 2E, are vessels that are intended for or are capable of transportation of cargo, as well as continual movement. Accordingly, the Castral I meets the necessary elements of an aircraft in the sense of Article 2E, as they are intended for and are capable of transportation of cargo, as well as continual movement. If I may please refer the tribunal to page 35 of the record, which is an email sent by Mr. Blanchili, respondent COO2 respondent. In paragraph 4, and I quote, it states that this naturally also makes the Castral I 2010 suitable for other purposes, in particular to bring high value and sensitive other loads to the remote areas of the northern provinces. Furthermore, if I may also...
May I interrupt there, please? At the risk of jumping the gun. You also please address us on the question of what these UAVs are capable of doing, to what your opponent was talking about what is the actual use and what is the intended use. So capability versus intention and actual use. Thank you.
Yes, Madam Arbitrator. As claimant has stated, it is the intention of the parties that stipulates whether an aircraft classifies as one under Article 2, and accordingly, respondent has the intention of using the Castral I for transportation of cargo as well as continual movement. which are the necessary elements of an aircraft.
Could you assist me with pointing to the evidence with regards to the intended use for transporting?
Yes, Madam Arbitrator, as Mr. Presiding Arbitrator has noticed, in the purchase and supply agreement in page 10, it is stipulated in the fourth paragraph that in the process of negotiations, the scope of the agreement to be awarded was changed to reflect new developments and a possible additional use of the aircrafts. Thus, in addition to the intended purpose of the aircrafts, which is aerial surveillance, respondent also has the intention of using the Castrol I for other purposes, such as bringing cargo to the remote areas of the northern provinces.
I come from a common law background, and I may suggest to you on you pointed me to are merely recitals. And is there a specific clause or requirement in the contract itself that requires these UAVs to actually be able to carry or is intended to carry payloads? Not so much, but actually capable of carrying payloads.
Yes, Madam Arbitrator. The case of Inri Ayers Aviation Holdings of 2002, the U.S. Bankruptcy Court has stated that the mere capability of transporting cargo is enough for a vessel to qualify as an aircraft in the sense of Article 2E of the Convention.
Sorry, perhaps I was not being very clear. Can you point to me in the contract where there is this requirement for the capability and payloads and the intention to use it as such, apart from those recitals?
There is no specific provision in the contract that states that the Castrol I has the capability of carrying cargo. However, if I may please refer the tribunal to page 44 of the record, which is the procedural order number 2. It is stipulated in elaboration number 9 that both the Castrol I as well as the Hawk I are able to carry other cargo fitting into the payload base, thus having the capability of carrying cargo.
Counsel, I'm sorry to interrupt you, but there's a technical problem that I don't know if the microphone is too close to your papers and if you're touching the microphone as you go through things, but it is very difficult to pay attention. It's like something is hammering through my ears. So I don't know if you can potentially put your microphone farther away from your papers or attempt to.
I apologize.
So no, it's not your fault. This will not happen in an in-person hearing, but here's the post-COVID world that we're in. Thank you. Let's see if that works better. I do have a follow-up question to Madam Sui's question, which is we agree there's nothing in the contract other than the recitals that talks about your client's intent to use this to transport cargo. Yes, you've conceded.
Yes.
Okay, and when we do look at the recitals, the first whereas tell us that you're doing this in connection with the North Part Development Program. The second recital tell us that you're implementing a strategy to explore the northern provinces. The third recital talks about the tender, which requires state-of-the-art aircraft, unmanned UASs for the collection of relevant geological information. The fourth whereas tells us that Drone Eye, the claimant, was the successful participant in the tender. We don't get to these possible additional uses until the fifth recital, correct?
Yes.
The previous page in the case record is the call for tender, which says nothing about other uses. It only talks about the collection of the geological data. Yes?
Yes.
Now going back to the contract, if the first four recitals talk about collection of data, isn't collection of data your primary purpose for using these drones.
Yes, the main purpose of the Castrol Eye is the collection of that data. However,
so if the main purpose is to collect data and not to transport cargo, not to transport people, because it's not capable of transporting people, then it is not an aircraft according to your own definition. It does not carry people, it does not carry cargo. That it's not its primordial intended use. So doesn't the claimant win and you lose?
It does in fact carry cargo, and the possible additional use of that aircraft,
No.
it doesn't require.
So there's two things happening here, and you keep dancing from one to the other when you don't answer a question. The first is the intent, the second is the capability. We've talked about the capability. You went back to intent. Now I'm asking you about intent. Please don't move back to capability. The primary intent is to transport, to obtain data, not to transport cargo. Yes or no?
Yes.
If the primary intent is to obtain data and not transport cargo, doesn't that mean you lose and the claimant wins?
A member of the tribunal, the intention of the party does not have to be specifically the main purpose for that usage. Any additional use or intention of the party can also be used in order to determine whether that object falls under the exception of Article 2E. Thus, regardless of the main intention of the party, the fact that it also has the intention of using it for the transportation of cargo also allows it to meet that requirement.
Just in follow-up to that, you had directed our attention to page 44, PO number 2, item 9. And I noticed in there that it also tells us that in order to be able to carry payloads, there needs to be some modifications.
Yes.
So again, I mean, this emphasizes what Mr. President was talking about. And so can you also address this in part as part of your answer to Mr. President's question?
Yes, although the surveillance equipment would have to be removed in order to carry cargo on the Castrol Eye, that does not take away from the intention of respondent to use the Castrol Eye for other purposes other than aerial surveillance, which would be transportation of cargo. In that same question,
I'm sorry, it comes back again to my original question, which is the distinction between intention and capability versus actual use or being actual use or the primary intention. There are two different things here. Yeah, one is possibility and one is actually true intention and actual use.
yes. And in the case at hand, respondent submits that the Castrol Eye that the respondent has the intention to carry the Castrol Eye to carry cargo, as well as the fact that the Castrol Eye has the capability of carrying cargo. Thus, it meets those both of these distinctions.
I'll leave it at that for now, Mr. President.
Thank you, Madam Sui. Madam Miriam, I have one additional question on your first point as to the applicability of the CISG before we try to move on to your second point. You had mentioned that registration was at issue here, and I would like you to go to page 36 of the case file, please. That is respondents exhibit number 5, your exhibit number 5.
Yes.
So in order for something to qualify as an aircraft under the law of Ecuatoriana, the law that you propose applies, right?
Mm-hmm.
Something needs to be able to carry cargo, needs to exceed 90 centimeters for their payload, higher than 50 kilograms, and it needs to be registered, right? An aircraft owned or operated by a private entity in the territory of Ecuatoriana shall be registered at the aircraft registry. There is no such requirement here, is there?
Yes, in the case at hand, the Castrol Eye does not have, there is no registration requirement for the Castrol Eye as it is operated by a state-owned entity.
So the aircraft in the UAEs in question, they would not qualify as an aircraft, even under the law that you propose should apply. Even under Ecuatoriana law, these things are not aircrafts.
No, Mr. Presiding Arbitrator. If you look at the first article, the definition, it is stated that aircrafts are any vehicle with or without an engine heavier or lighter than air that are used or intended to be used for moving persons or objects. And they are the ones that have their overall length exceeding 90 centimeters and their payload is higher than 50 kilograms. Accordingly, the Castrol I is to be intended to be used for moving objects. And furthermore, the Castrol I's length exceeds 630 centimeters, and their payload is higher than 245 kilograms, meeting the requirements of an aircraft under Equatoriana law.
Thank you, counsel. Do we have anything further from Orlando or Sui on the applicability of the CISG before we move to termination and misrepresentation? Nope. Awesome. Counsel, I understand that we're running a little bit late today. We have a lot of questions from the tribunal. We apologize for that, but we would kindly ask that you attempt to conclude your second point within 5 minutes.
Of course, thank you.
Please.
Moving on to the second submission, which is that respondent can rely on its domestic law to avoid the contract. This is due to the following two reasons. Firstly, that there's an external gap present in accordance with Article 7, paragraph 2 of the CISG. And second, that claimant's conduct fulfilled the requirements of fraud in accordance with Articles 3.2.5 of the ICCA. Firstly, there is an external gap present in accordance with Article 7 of the CISG, allowing for respondent to resort to its domestic law. According to Article 4A of the CISG does not deal with the matter of substantive validity of the contract and is considered therefore an external gap. Professor Schlestream also emphasized the meaning of substantive validity in the sense of Article 4A by stating that if a contract is declared void by reference to a domestic law due to vices of consent such as fraud, the matter is governed by the domestic law and not by the CISG. And accordingly, respondent's claim is a claim for fraudulent inducement, not nonconformity as claimant has stipulated or claimed. And the matter of fraudulent inducement is an external gap present in the CISG and accordingly needs to be governed by the domestic law applicable. Respondent has terminated the contract due to claimant's fraudulent misrepresentation of facts related to the Hawkeye. As illustrated in the procedural order number 2, respondent would have profited from the additional functionalities of the Hawkeye, the longer endurance, as well as the satellite communication system, including the higher ceiling and the greater payload, would have enhanced the quality of surveillance and would have been more suitable for missions in the remote areas of the northern provinces. Claimant repeatedly requested for the drone to be claimant's top model of drones as well as state-of-the-art. However, after nearly 2 months of conclusion of the contract, claimant presented its newest top model of drones, the Hawkeye, with the knowledge that claimant was under a legal obligation under Equatoriana law to disclose any relevant information regarding any improvements or developments regarding any product related to the contract.
Counsel, I'm sorry. Madam Sui, please go ahead.
So just to stop you there, you said that there was a disclosure obligation. Can you please assist me with where the obligation arises from? What do you rely on?
That obligation is under Equatoriana law. And if I may please refer the tribunal to page 18, which is the witness statement of Horatia Porter, claimant's legal department lawyer. As stipulated in paragraph 3, it is specifically stated that claimant checks any legal requirements when conducting negotiations with a state-owned entity, and it is additionally examined whether there are any special requirements when contracting. And accordingly, claimants should have known that they were under a legal obligation to disclose any relevant information regarding the presentation of the Hawkeye, as respondent had the right to choose the most suitable drone in accordance with its requirements and needs. Members of the tribunal, I note that I have...
Counsel, yeah, you don't have to worry about the time. I would like to please go to Claimant's Exhibit number 1 at page 9 with you, please. This is your call for tender. This is something that your client put forth before they ever conversed with the claimant. Yes?
Yes.
Did your client rely on claimant to put together your call for tender?
No.
Your
However,
client rely on any advice from any representative from the claimant in order to determine what were the technical specifications for the drones that your client intended to purchase?
no.
So
However,
when your client wrote this call for tender, your client determined that your client wanted a payload weight of 180 kilograms. Yes?
As specifically stated, this is the minimum requirement that respondent requests. However, that does not change the fact that there could have been a more suitable or more advanced drone available that the claimant could have presented.
But isn't it your obligation to determine what you think satisfies your needs? Why is the claimant's obligation to help you?
Member of the tribunal, respondent had no awareness of the existence of the Hawkeye. Therefore, claimant had the duty to disclose the existence of the Hawkeye in order for respondent to choose the drone that it found most suitable in accordance with its requirements and needs.
Counsel, the market had knowledge that the Hawkeye was in development. Your client could have done its research. Your client elected not to do its research, and your client elected to rely on a duty that it never disclosed to the claimant that the claimant had.
Claimant disclosed in 2017 that they would eventually in the future develop newer drones. It did not specify specifically that they would be developing the Hawkeye.
Okay,
Sorry,
Counsel. Okay, Counsel, but Madam Sui, please go ahead.
Sorry, I'm just circling back again in relation to your question, Mr. President, which says this obligation to disclose that you rely on. Where is the obligation? I'm sorry, I still don't follow your answer to my earlier question. And this is crucial to what Mr. President is talking about.
Of course, member of the tribunal, that duty to disclose can be found specifically in page 29 of the record, which is respondent's notice of arbitration, in which is stated that under Ecuadorian law, whenever a private company, in paragraph 18, whenever a private company is contracting with a newly formed state-owned entity, it has a disclosure obligation covering all information potentially relevant for that government entity. And accordingly, claimant, as they specified that they have done their research regarding the legal requirements, should have known that this was a legal obligation that they were under.
I'm sorry to interrupt you. Can you please point to me exactly which paragraph you're talking about and read the relevant language so that we can understand what you mean?
Of course. In paragraph 18 of page 29.
Okay. I'm there. Can you please point to me where this talks about the CISG?
This relates to their obligation under the Ecuadorian law, not the CISG.
So this is a case from the Ecuadorian Supreme Court.
Yes.
That it held in 2010 that an experienced private party, if I understand correctly, the claimant puts out 5 drones a year, right?
Yes.
So in your position, somebody who puts out 5 drones a year qualifies as an experienced private party.
Yes, given the fact that drones take a reasonable amount of time to develop and be put out onto the market.
Okay. Now, the next part of the puzzle is that it says that it's a newly formed government entity, right?
Yes.
Your client was set up in 2016, and the contract and the bid was called for in March 2020, and the contract was entered into in December of 2020. By that point,
Yes.
your client was 5 years old. Does that qualify as a newly formed government entity?
Yes. Respondent submits
5-year-old
that.
company qualifies as a newly formed.
Yes.
Okay. Now, this Supreme Court case upon which you rely, it's talking about far-reaching disclosure obligations, covering all information potentially relevant to the government entity, extends to planned improvements on the product. Does this case apply to every contract entered into, or only to construction contracts?
Any contract between a private entity as well as a state-owned entity, which meet these requirements.
It is not limited to infrastructure contracts.
No.
Are you sure about that?
Yes, Mr. Presiding Arbitrator.
Okay, then please proceed.
This concludes the submissions for respondent. And respondent can rely on his domestic law to avoid the contract, since claimant fraudulently led respondent to enter into the contract by failing to abide by their legal obligations. And for the foregoing reasons, respondent respectfully requests the arbitral tribunal to adjudge and declare that first, the tribunal lacks jurisdiction to hear the case. Second, the arbitral proceedings be stayed or alternatively bifurcated. Third, that the purchase and supply agreement is not governed by the CISG. And fourth, that respondent can rely on its domestic law to avoid the contract. Thank you.
All right. I just have one last question for you, counsel, that I'm also struggling with. I understand the arguments that you're making about this, the requirement that I'm asking you to please go to page number 10. It's again the contract.
Yes.
Article 2, it's talking about the seller's obligations, the claimant's obligations, your counterparty's obligations. And it says that they're required to deliver. I'm reading from paragraph 2A now. It says to supply to the buyer, to your client, 6 of its newest model of Castro I. The newest model of Castro I. Is the Hawkeye a model of Castro I, or is it a different I?
It's a different drone.
So the Castro I 2010 is actually the newest Castro I. There is no 2020 Castro I. There is a 2020 Hawkeye, which is not the Castro I. It's a different I.
Yes. In the call for tender, respondent requested the top model and the state-of-the-art of a drone, not the Castro I specifically. And respondent entered into the contract because it was falsely led to believe that the Castro I was claimant's top model of drones, which turned out to be
Indeed,
false.
counsel, but the contract says Castro I. It doesn't say the newest model of any I available possible. It says the newest model of Castro I. They have delivered, or they would have agreed to have delivered the newest model of Castro I. And also, Madame Sui, a point ago, mentioned that the contract contains an entire agreement clause, an integration clause, which exclude evidence from previous and extraneous documentation, certainly one that would contradict the express language of the contract, right?
Yes, Mr. Presiding
The tender doesn't save you, is my point.
The call for tender can be used to determine the intention of the parties, and accordingly, it can be interpreted by the call for tender that claimant had the intention to defraud respondent, as they failed to mention the existence of the Hawkeye, which is why respondent entered into the contract due to the fact that they did not know the existence of the Hawkeye.
Certainly, counsel, but you just bear with me for a second. The fact that they have a contract with you does not mean that they will have to stop their R&D department entirely. Because if we follow your understanding, so long as they have a contract with you, they cannot develop a new drone. Because every time they develop a new drone, they will automatically be in breach of this contract. So that means they have to stop in time, do one thing and one thing only forever, as long as this contract is alive. That is your argument as you sit here today.
No, Mr. Presiding Arbitrator, respondent merely requested that at the time of conclusion of the contract and the negotiations, that claimant disclose all relevant drones or all drones of the newest technology, which would include the Castrol Eye and the Hawk Eye. And accordingly, a respondent can choose the most suitable drone, which would then lead claimant to potentially develop newer drones after the conclusion of the contract.
Okay. Anything further from Sui Orlando?
Yes, please.
Please, you
You
have.
refer back to the call for tender at page 9, and you rely on the phrase state of the art.
Yes.
Guide me where I should look to for the definition of what constitutes state of the art or what falls outside of the state of the art. Thank you.
Member of the tribunal, there is no specific definition for state of the art. However, based on the reasonable understanding, state of the art can indicate the newest technology or the most up-to-date technology and drone of the seller.
And where did that come from? That definition? I may have missed it. I'm sorry. I was writing something.
No, I did not reference that definition. However, as Mr. Presiding Arbitrator has stated, we can merely use general definitions to apply to that case.
Thank you.
Thank you.
Nothing further. Thank you, Mr. President.
Nothing further from me either. Orlando, are you satisfied? Okay. In that case, oh, I'm sorry, we still had rebuttals. Pardon for that. Diego, or Mr. Aguayo, are you prepared for your rebuttal, sir?
Yes, Mr. President.
You have the floor.
Thank you. In recent, since the respondent confirmed that the classification of aircraft is a matter of intention, in reason that the UAVs supplied by the respondent are to be integrated according to the Northern Development Program of Ecuatoriana, which unique mission is the collection of relevant data and not the transportation of goods, it's crystal clear that the CIAG is not excluded to apply to the contract since the classification of UAVs are not aircraft. Thank you, Mr. President.
Thank you. Madam Miriam, do you have anything in reply?
Yes, members of the tribunal, as I have stated in my submissions, regardless of the main intention of respondent, the fact that respondent still has the intention to use the Castrol Eye for transportation of cargo, this allows it to qualify as an aircraft in the sense of Article 2E, and thus the Castrol Eye, the CISG cannot be, the CISG cannot govern the PSA. Thank you.
Thank you. All right. Then perhaps we can have some assistance from the Secretariat to.
Marcio, I don't have further time. If you want me, I can give comments now because I have other commitments. So otherwise, you can proceed, and I give no comments as you prefer.
No, I mean I'm happy for you to give your comments, but we still want you in the room, right? Like we.
I mean, I would give my comments now. I don't have further time.
Okay, no, but just so that we figure out like the who won.
I don't have further time. Sorry.
Oh.
Well, if you want, otherwise you can continue by yourselves, and I can.
No. Please go.
Okay.
Go ahead.
Well, I mean, I've been participating in this type of competitions during 13 years. And I have to say that this has been the most contentious or perhaps the most I don't know the word. I think you were exposed to a tremendous amount of violence, and hopefully it's going to be helpful for the actual competition. I just have a couple of questions that I may, well, not questions, suggestions. I believe that you have to be consistent in your positions. Marcio pointed a couple of comments that, for instance, Diego and Angel, you have inconsistent views, and of course, this is unacceptable. Yusef, you have to be more prepared. I guess, of course, we're not native speakers, and as not native speakers, we have some deficiencies, but I guess you have to work more on your oral presentation. And for that purpose, I would ask Miriam to please assist him in being more fluent, more natural. And as a general comment for all, I would say that sometimes, and this is in life, sometimes we don't have much room for improvement because our clients, unfortunately, they took the worst positions, and we have to work on that. So be mindful of that. And sometimes Marcy was asking some questions, and I mean, you have to say, Mr. President, I mean, that's the position of my client, and I don't have a better answer, or I don't know, because in some instances, the facts of the case do not allow room for improvement. Many of the questions Marcio was putting forward perhaps are not easily answered because the facts of the case, again, do not give that possibility. So you have to be careful and very attentive where to how you draft your answers, and how you craft your answers is essential, because of course you don't want to enrage the tribunal, but to say Mr. Chairman, I'm terribly sorry, but I don't have a better answer. This is the position of my client, and the facts of the case do not provide. So any answer that I may give you could be pure speculation, and I think that's enough. But if you are not smart enough to detect how to stop the tribunal, then you give room to continue and continue and continue. So be extremely careful how you craft your answers in order to avoid speculation, to be careful how you answer, given that we have a specific fact pattern, and you cannot go outside of the facts of the case. So with the facts of the case, see if you can answer, and you have to master those facts. But if the answer is not here, you cannot speculate. So if the intention of my client, if he is not here, Marcio was asking why one of your representatives, Diego or Angel, was not here. I mean, Mr. Chairman, I would have answered. Mr. Chairman, the facts of the case do not provide an answer for them. That's it. That's it. That was, in my opinion, I think that would have been the best answer. But anyways, so just a couple of questions, a couple of suggestions. Hopefully they are useful. I'm terribly sorry that I need to leave for another commitment, but congratulations. I mean, I think you are doing very well, and I am very confident that after this round of heavy questions, you will succeed, and you will have lots of good experiences that you can tell us and share with us later. So congratulations, and I'm terribly, terribly sorry that I need to leave, but I had not allocated so much time. So congratulations, and once again, sorry for that I need to leave.
Thank you, Orlando. Thank you. I did send you a little text if you can, when you get a chance, it could be on your.
Sure.
But I would ask the teams for patience for a moment. so that Sui and I can have a conversation. And so I would ask for our friends from the Secretariat to get us to a breakout room or get us out of here for a second.
Yes, I'll take you to the breakout room right now.
All right, thank you.
Yes, you're back.
Awesome. Thank you. Thank you. All right, guys. We can all take a deep breath. We can all relax a little bit. All right, it's over. It's done. We have survived. Everything is okay. This was a very hot panel. The reason why we've made this a hot panel is because we have very high expectations for both of your groups. And we wanted to assist in that preparation by making this one of the hardest practices you'll get. We have some suggestions that we have for your improvement, and some comments, some general comments and some specific comments that we want to make. And Sui will start, please try to use this time as a constructive thing that you can use to help your presentation and your preparation going forward. Sui, please go ahead.
Thanks very much, Marcio. Guys, first of all, congratulations on reaching this round. And firstly, also, I highly commend you for taking part in this and for doing all your preparations, because I'm new to meeting. You know, I've only been doing and judging this in the last 6 years or so, rather than a lot of you who have been taking part in it. And I can see the development that has been so beneficial in taking part in moots and taking part in more and more moots. So I say that with particular reference to Malaysia, my home country, where there is no tradition of mooting until people like Louis came to Malaysia to work here. And to the extent that I have seen within 2017 to today, the huge strides made and how this helps. So based on that actual evidence that I see with my own eyes, I commend all of you and encourage all of you to carry on. I'm going to make comments on each of your presentations. Please do not consider these to be criticisms. They are more intended to be feedback for you, something that you can listen to and try and take on board. And as Marcio says, I'll also make some general comments. So in no particular order other than in order of speakers. So I suspect that English is not your first language, and I struggle a little bit with that. I understand that English is not everybody's first language, but unfortunately, it is the first language of commerce and the first language of international dispute resolution. So like it or not, I think that we all have got to grasp that very, very well. You can call it a bias, but it's the reality of the world. Yusuf, I think that you were reading too much, and that is something that will come, that you will overcome with more and more participation. Yeah. You responded to Marcio quite well and directly, in a sense that he asked you a question, you're able to, you want to actually address it, and you do address it, albeit your responses do not fully address the question, and you tend to go back to your fixed prepared position. Sorry, the sun is in my eye. I started at 6 a.m. and it's now 8:43 a.m. So the light is very different. So don't worry about that. Okay. So I think that this is something that, again, as you prepare more and you are able to go off script a little bit more, that's going to help you, and that can only come with practice, and with practice comes confidence. You have been good at listening to your proceedings, and these are great things. So Yusuf, you are on a great track. Move forward, do more, and I'm sure you enjoy it much more and be less nervous too, okay? So congratulations to that. I move on to your next speaker, Angel, and you speak very, very clearly. I think that that's a natural pitch of your voice. I know that I can speak clearly because that's my natural pitch of my voice. So people like you and myself, we have an advantage because we can project. Remember, everybody, that you are selling an argument always. If I can't hear your argument, I can't hear your sales pitch. So it is very important. You're not speaking for yourself or your colleague, you are speaking to your audience. we are actors on the stage. Yeah, so we are always salespeople in that sense, selling an argument. You, Angel, you answered questions directly and you have good grasp of facts. I think that in some cases, like myself, I know you speak too fast. And sometimes you're also over-speaking yourself or over-speaking the other person. So just take that into account. Diego, you had you came across as very well structured. You had good pace, but again, the natural pitch of your voice was that it made it a little bit difficult for me to hear. Now, I am conscious of the fact that our language backgrounds are different, so I understand that sometimes it is my problem, but like I said, if it's my problem, then it becomes your problem because it's difficult for you to sell your pitch. You two were a little bit too wedded to your prepared case, and you struggled a little bit to address the tribunal's question because you had to always go back to your prepared case, okay? So again, like what I said to you, so as you do more and more and more of this, you get to be more holistic in your preparation, and you are able to work within that general framework. I'll come back to this in a little while in my general comments. Miriam, congratulations, the only female in this panel of guys, but you were not intimidated. That's really good. You and I come from a cultural backgrounds where perhaps it is more patriarchal, and for us as women, it's sometimes a little bit intimidating. So I acknowledge the fact that you have an additional hurdle, and I commend you for being where you are and doing what you're doing. You were clear, you had very good pace. You really had, I think, difficulty in answering answering the questions unless you were asked very specific questions. Meaning to say that if I give you a overall scenario, you were struggling a little bit, but if Marcio asked you very direct questions, then you were able to answer. Again, I'm not sure that this may be a question of understanding where I was coming from, and that may be also a question of language and context. In certain cases, I think I was a little bit, the way I asked the question was a little bit sort of woolly, a little bit vague, and that's my issue. But as I said, if it is my issue, it becomes your issue because all arbitrators, or in fact, all witnesses or oppositions may actually do that deliberately to cloud the issue and make it difficult for you. You were a little bit nervous when pressed, and you were pressed a lot, as all of you were, and you did not answer directly. And again, I think this comes with practice and confidence. I will make some general comments now for all of you. One of the general comments I wanted to make was that I think all of you tended to gloss over the precise basis of the arguments and the evidence that you rely upon, that you presume that it was present in the material and taken as read. I agree they're taken as read, but you will hear that I have pressed each one of you quite often, a lot of you, as to please lead me to the precise bit of evidence that you rely upon for a certain allegation, fraud, whatever it may be. Okay. That another overall thing is that as much as you are dealing with specific questions, one cannot forget the big picture. So you need to have an overall case that hangs together, even though you are having to answer very direct and precise questions and challenges. So this ties in with what Orlando was talking about, being consistent. And this also ties into what I talked about, your overall picture. When I give a lot of talks, I always talk about the fact that when you have a prepared case, you must not lose sight of your overall picture. I speak to the fact that if you rely on Google Maps or ways to find you a route to your destination, but you do not even know whether your destination is north, south, east, or west, if Google Maps, you lose connection, you lose your direction, you don't know where to go. So you must have your overall context and your overall case and your overall direction. If you're going north, you're going north. If Google Maps goes, you lose connection, or if there is, for example, a roadblock and you have to go to a different route, you still know where you are going. So keep this in mind, and this is why sometimes I ask you questions, they're not specific, they are very wide. Okay, so this is the reason why I ask you to do that, because think of it, we as arbitrators or judges in a moot, we don't know your case. You need to tell us how to guide us through this case. You are our Waze and Google Maps. All right, so the whole overall case is important. I make this comment, and I hope this is not inaccurate, because it's a little bit more difficult to see things in a virtual situation than in person. But I did not see a lot of notes being taken by any one of you in preparation for rebuttal. You were not taking a lot of notes as to what the other person was saying before you did your rebuttal, which indicates to me that you are not necessarily rebutting on the basis of what you have heard, but you're rebutting on the basis of what you have prepared. Now, by and large, in the moot, that doesn't, it's not such a big deal, but I can tell you in a real case, that's a huge deal. The other thing I'll also say is that in some moots, it can become a major issue as well. So you need to be listening a lot more, and so that you can be a lot more precise and pointed in your rebuttal. Okay, so the way I think I would close it off by saying is that I congratulate all of you. I think all of you did a really good job. I think that you should continue more and more and more, and you enjoy it more, be more confident, and be more smooth in your presentations. And on that note, I hope that perhaps I will see some of you in Malaysia in March for the AIAC Viz Pre-Moot, where I'm also judging. So on that note, thank you, ladies and gentlemen. Congratulations, and keep up the fantastic work. Really enjoyed listening to all of you. Over to you, Marcio. Thank you.
Thank you, Sui. I agree with everything that Sui had to say. So I have a few general comments, and then I have a few specific suggestions for each of you, what I think you could be doing, should be doing, may benefit from doing. The first thing that I want to say is that I believe in the moot. I'm a big believer in the moot. I did the moot 2 times as a student. I did the moot 8 times as a coach. The last time I didn't actually go to Vienna, but I participated during the whole preparation, so it's more like 7.5 times. But this is a very, very powerful preparation mechanism for your practice. The people who come out of this, and the people who do this right, like the 4 of you have done this right. Like you've studied, you've prepared, you've endured. The people who do this right, they absolutely benefit from it in their practice and in their professional career. I mean, the fact that it's Saturday and we're all here doing this, it's already an indication. I took a lot of time to read the problem this week, and to think of questions that I think you might face in Vienna, or in Hong Kong. It would have been a lot easier for me to just come here, be quiet, listen to you, then pick one of you as a winner and then go home. I could have done that in about an hour and a half. Didn't have to read the problem, didn't have to do anything. That would have been a lot easier on me, and maybe my wife would be less upset with me for being here so late. But I don't think that I help you if I do that. If I come here and I shut up, I don't think I help you. The best way I can help you is to be as nagging and as annoying as I can possibly be, because hopefully Vienna will be easier. Hong Kong will be easier than what you've seen. So the way I look at this is I'm gifting you the 30 or 40 questions that I think they might ask you. And so now you've thought of them, you've heard them, you can think of answers, better answers. You can read, you can see the recording again and then work on it. And then hopefully if somebody is as annoying as I am there, it will not be the first time. So that being said, this was a hot panel. And this was the type of panel that you will see if you advance to the elimination stage. This is not a panel that you will see in the general rounds. The general rounds are closer to the 14 minutes plus one. Arbitrators will have one or two questions. There will be typically more generic questions, very few factual questions. A lot of the arbitrators will not know the facts, especially not in the first day. So you will have more of your standard prepared presentation. However, with each passing day, you're required to improve. The notion being that day 2 is better than day 1, day 3 is better than day 2, day 4 is closer to elimination rounds, right? And so by that point, you should know when you go into a round whether you're performing at a final elimination stage level or not, right? And so in that elimination day, the clock goes longer. You're expected to go between 20 and 25 minutes. It's mostly questions, very little time for you to make the presentation you've memorized, prepared, summarized, written. They will usually give you the first 5 minutes as a freebie. I try to do that with you today. I did not interrupt you in your first 3 to 5 minutes. That is typically the time you're going to have in an elimination round in Vienna. And so you have to use that time very well. But for as annoying as I was with you all today, I do want to give you some tips on how to get out of what I was doing to you, okay? And here are the tips of how you get out of the problems that I try to put you on. You have to know the facts very well, because you will face some arbitrators who will know the facts very well. I've done enough of these that I know what the facts, which facts to focus on when I see them. And it's usually where there's going to be like a conflicting position, like what contradicts what. And so you have to know the facts very well, because if you make a factual mistake, arbitrators will massacre you. I mean, I was bad with you today on facts, but you will see some arbitrators who will not stop until you admit you said the wrong thing. I try to do 1, 2, or 3 questions. I did not do 4 or 5 questions on a factual error. Some arbitrators will literally massacre you until you admit that you say, "I'm sorry, I was wrong." And I've seen people cry. I've seen people I've seen it go bad. Like I've seen it get bad. So like you absolutely cannot make factual mistakes in any way, shape, absolutely no way, shape, or form. Which is easy, right? That's just reading the problem over and over and doing these practice tests over and over. But the way you get out of a question, especially the questions that are difficult, is the following. First question, you stand your ground. I said what I said and I stand by it. The second question, you feel it out. If the tribunal, if you've swayed them, cool, move on. If you did not sway them, and the question comes a third time, you have to move to a subsequent line of argument. You cannot keep, I'm not going to say the term that I usually use to explain this, but it is a downward spiral. It is a blank spiral, right? You need to get out of that downward spiral. The way you get out of that spiral is by changing the argument. So here's what I have, the mission that I have for the 4 of you. Make a chart, okay? Each of your arguments needs to have what facts you rely for it. What is your legal background? If it's a procedural jurisdictional argument, it's going to be model law. It's going to be the PCA rules. It's going to be what is the rule that you're relying on. And then you have to have either a case or a scholar that supports your position. If you don't have all 3, you don't have an argument. So you need all 3 for your argument. And then you need to have subsidiary alternative arguments. If argument 1 is not working, go to 2, do the same thing. If 2 is not working, go to 3, same thing, and so forth and so forth. All of you had 1 or 2 arguments for each of your points, and you stopped there. This is exactly what I was testing. Do you have alternative options for when something is not working? The beauty of this is that once you prepare 5, 6, 7, 8 alternative arguments, you will have thought of everything that can come up. So a tribunal asks you a question. I asked Youssef about agency. You should have thought of agency. You should have an answer for agency. You should have an answer for estoppel. You should have an answer for venire contra factum proprium. These things are going to come, right? And so if you have an answer that's mapped out, that is a perfectly round answer. Somebody asks you about agency, you say, well, Mr. Arbitrator, I'm glad you've asked me about agency. In reality, my client has considered the theory of agency and it doesn't apply because it contradicts these facts. The law does not concern itself with this or that proposition. Such scholar has refuted that theory on this basis because X, Y, and Z. Now you have a full, complete, round answer, gets you out of agency. If the issue is estoppel, you have a round answer, gets you out of estoppel. So this is the thing. If you have one or two things, and you insist on one of those two things, and all you can do is go from A to B back to B from A, you're stuck in a loop. That's not a good place to be in, right? So you have to be able to get out of that spiral. The way you get out of that spiral is, well, Mr. Arbitrator, it is my client's contention that agency does not apply here, that the constitutional requirement still stands, and that the arbitration agreement is therefore invalid. However, if you're not convinced by that argument, and you want to engage in a estoppel agency venire contra factum proprium principle, those still also do not save claimant's position, and here's why. So you need to be able to recognize when in this give and take they're not on your side. It's not working, right? You can't just go back from A to B, back from B to A. That will not save you. That will not resolve your problem. To make matter worse, time is your most valuable currency, right? You will not have 30 minutes in Vienna. That's not going to happen, right? But the time that you waste by answering a question on a loop is time you don't get back, right? So like time is the most valuable currency. So you need to be able to show in that time as much of you as you can. Answering the same question 3 times, it's not a good use of that time, right? Because it's not showing the full scale of the study you've put into this, the full spectrum of your preparation. You're just like in a tug of war with me, and like that's, and so you're actually wasting your most valuable currency, which is your time. Okay, so please try this system. There's various ways by which people prepare. When I did the moot, I had a chart for each point. So jurisdiction, for example, for the procedural jurisdictional piece, jurisdiction would be one chart, and the stay or bifurcation would be another chart, right? And so like I have 5 or 6 or 7 points for why I win on jurisdiction. Strongest to weakest, and then you keep running down your list. You know, you don't give in. You say, this is my client's position. But if you're not convinced, and if you want to go to that theory, I still win on that theory. And here's why. And then you're going to tussle on that for a minute. If that doesn't work, and they come up with something else, you'll say, well, my position is that I win on estoppel. But if you want to go on this, I still win on that as well. The point is, when you're done, you should be able to say, under any theory, under any circumstance, I win. Doesn't matter how you look at this, I win. If you want to apply Equatoriana law, I win. If you want to apply the Nubia law, I win. If you want to apply the CISG, I win. Doesn't matter what you apply, I win. You want to be able to close with, in any scenario, under any circumstance, I win. Okay? All right, so that's how you get out of the downward spiral. Okay, that's the trick. If you need time, if it's aggressive, like I was very aggressive, right? You have mechanisms like you drink some water, you take notes of the question, and then you try to think of the question, and you try to work that question through to get you to your answer. Most likely, the answer is going to be the next point, the next argument, the next thing that you're going to go to anyway, right? That's how you get out. That's how you get out. So answer once. If it doesn't work, answer twice, but kind of see how the tribunal is going. If you get it a third time, get out. Okay? That's the trick that I have for you. That is the solution to the problem. All right. That said, and I want to emphasize the point. You guys you're in the top 4, right? This was a long day for all of you. This is your 4th round for the day. You're all tired. I have no idea what time it is where Yusuf and Miriam are right now. You know, in ordinary circumstances, if we were all in person in sunny Cancun, I would be buying you guys tequila shots right now. But which I highly recommend you do before the day is over. But you know, you get to the final 4, you're getting to the end of the competition. You're among the best teams. This is a pie winning contest in which the prize is more pie, right? So you're going to get harder and harder tribunals, hotter and hotter questions, more and more aggressive. And so like, this is what you guys signed up for, right? This is what this is, you know? So, all right, enough. I have some very specific things. I'll try to go, you know, a minute a pop, but I'll go also in the order in which you guys made your presentations. Youssef, read a little bit less, focus a little bit more on us, and have some more punch, okay? Your presentation was a little bit robotic. I think you need to have a little bit more punch, more aggression, more blood in your eyes, all right? You're representing a state, and there were a lot of red flags for corruption, all right? So you need to open your presentation, start your thing by saying, we're here today because these guys are a bunch of crooks, a bunch of corrupts. They're here to try to steal money from my people. That's the problem. That's why we're here today, right? So you got to, off the gate, or fire, right? You're here because somebody's trying to steal money from your people. So you struggled a little bit with like agency, stop all those kinds of things. You're going to clean that up, I have no doubt. So don't worry about it. It's fine. I like how you stood your ground on the Fonseca issues, right? I was trying to bother you about her and her nephew and her brother-in-law and whatnot. And you're like, no, she stands for the good thing. She fights the good fight. That was very good. But I think you were missing some more stuff on the stay and bifurcation, right? Which is where it's good for you. Stuff like, start saying something like, where there's smoke, there's fire. There's all of this evidence of corruption from all of these people. They're trying to say it's nothing, it's something, right? There's a bunch of red flags here, there's something. And you need to make some of these arguments about like your right to be heard, your ability to present your case. The witnesses are not here. You cannot get Blitzky and present in front of the tribunal, documents from him, that kind of stuff. They're outside of the jurisdiction of your prosecutor. So not only they're stealing money from your people, but there's no way for you to make that evidence, right? So that's why you have to wait until the criminal investigations transpire, because then I will have evidence. And like, this is a short stay, it's a few months and whatnot. Like, Angel had a good answer to this, that like the 4 months that became 13 months and whatnot. Like, so you have to be prepared for that, but you have to have a little bit more, intensity in that point. And also like kind of push more the ball on their side. Like they knew that approval was required for the arbitration agreement. They didn't obtain it. They took a risk. It's like their fault, whatever. Try to push more the ball to them. Be a little bit less on the defensive. Now, Angel, I think that you have excellent demeanor. You're very charming, which is very good for you. Keep using that. I punched you a lot and you did not give in. And that is, you're supposed to be a punching bag. And you were a punching bag. And you were very good at it. So kudos to you, hats off. Keep doing that. That is what you're supposed to be doing. A few things that I think you can improve. One, your punch in your introduction is too long. Make it shorter, be more punchy. Don't talk about point 1 and point 2 before you talk about point 1 and point 2. Go into them and then let the ball roll. Keep it under a minute. You're at 2 minutes and a half, which is too long. It lost the intensity. Be very careful with the facts. You might get some people who like memorize stuff, some people who are also coaches and they know very well the facts and they will grind you on those things. I do think that you went from validation to ratification, which is fine. But I think that in the validation point, there's a lot of other alternative arguments. Work in estoppel, work in agency principles, work in how it was reasonable for your client to rely on the minister. If the minister doesn't talk for the government, who does? It's those kinds of things, right? There's a lot of good facts for you. And then put the tribunal's nose on the ratification, walk them through the record, show the email, show that they're ratifying something that they say doesn't exist, that's stupid, that makes no sense, right? So work on those kinds of things. So I think that the bifurcation and stay was good. I think the time frame for the arguments was good. I think all of that was good. Yeah, I mean, the last thing for you is just this general comment of being careful with the questions, because answering costs time, right? So the more you can go to the next thing, the better off you are in terms of time. Diego, I think you were a little bit less charming than Angel, right? So I think, and that's a personal characteristic, that's fine. I'm not saying that you're supposed to be Angel, you're supposed to be yourself. But I think it is something that he does very well, and to the extent that you can incorporate to your own presentation that's helpful to you, is to be that punching bag, is to be more charming. Let me convince you. Let me show you why I'm right, instead of like trying to get into a fighting match with me, because you will not win that fighting match, right? So the way you win is by charm, by convincing. So try to do a little bit more of that. That said, I did like the arguments that you were making, like the substance of the arguments, the historic interpretation. One analogy you can make is with ships, because the what is a ship is also something that comes from a historic interpretation. The advisory opinions work through that point. So that's something that you can incorporate. I think that what was missing, there was a gap in your presentation about how to get there. Like to say, why is it the dictionary definition not enough? Well, because what is an aircraft is in constant change. It's a technology issue. The technology moves faster than the CSG. The CSG was drafted in the 60s, 70s. It came into effect in 1980, right? So because of course that this is not going. Drones didn't exist in the 60s, right? Didn't exist in the 80s. So like this is why you have to look into something that's in flux. You have to look at more than just the mere text. So kind of work something along those lines. But I mean, I thought your conclusion was good. I thought your rebuttal was good. I think you dealt well with these issues. I have no doubt that you're going to round off your presentation. You still have time. Miriam, the same thing that I had to say to Angel, I have to say to you. You were very charming in your presentation, which is a strength that you have. That was very good. I think you did not like accuse the punch on the questions. But I do think that you need to be a little bit more, again, with alternatives for your arguments, right? One thing that you absolutely cannot give in is like the question of intent, like that their primary intent was not this or was not that. It's like, look, it's my client's position that they intended to use this thing for transportation. And then I mean, there were a bunch of answers that you could have taken, a bunch of routes that you could have taken. Like for an example, that the contract says that their intent changed, right? That once they've learned the capability of these things, their intent changed. You know, like this is a public company, is funded by public funds. They have an obligation to not waste public funds. You know what I mean? Like they're doing the best with what they got. You know, they're not like the commercial actors of the world. They're just buying some drones to develop a poor part of the country. Like they're trying to fight the good fight here. They're doing a good thing. You know, try to get a little bit more bona fides on your side. And the other thing that I would suggest to you is to like close the loop on your argument. Like sometimes you would say the right thing, but then you would not say what that results. Like therefore I win because, right? So like so to make the argument and then like close the loop. Like this means that I win because of this. You know, like to not just throw the concept out there, but like to actually like close the loop. But guys, I've already spoken way too much, but I just want to emphasize that you guys did a very, very good job. This was a very, very hot panel, way hotter. I mean, doesn't compare with the general rounds. Absolutely in no way, shape, or form. This was not a general rounds panel. This was an elimination rounds panel, and a very hot one, right? So hopefully this was the worst experience, and from here on out, everything will get easier and better and nicer and more fun. Okay. But in any event, we've tried to give you as much as we could to help you prepare. And best of luck in Vienna or Hong Kong or whatever it is that you're going. Remember to enjoy yourselves, enjoy this moment in your career, in your life, that you can do a case without a client, without a budget. Like you're not concerned about getting paid. You don't really care who wins or loses because it doesn't matter. So this one is just for the argument. This one is just for fun, right? So remember this moment, have fun. This will be one of the most fun experiences in your life. I'm very jealous and very happy for you. And I hope you have a very, very wonderful week in whichever one of the two moods you're going. All right.
Make friends.
Sorry,
make friends.
can we take a picture before everyone left, please?
Sure.
So please say tequila.
Yeah.
Yeah.
Cancun. Thank you very much for the arbitrator's time. Also, Congratulations to both teams. You all did great. And I hope this was a great experience for you. And thank you to everyone. So now we're going to start the final. Thank you.
Thank you so
Bye-bye,
much.
everybody.
Thank you so much.
Thank you for the amazing feedback.
Best of luck.
Thank you. Bye bye.